and colleagues from the Ministry of Justice. As you're probably aware, Minister, new standing orders mean that you might give us an introduction for 3 or 4 minutes, and then we go straight into questioning, as you may be aware of the new protocols. So the floor is yours, and maybe just let us know who's in your team as well.
Well, look, thank you very much. Do you want the whole?
No, at least we've got an idea.
Primary Andrew Kibblewhite, CEO, and there's a broad team from Justice here. And when I defer to them, I'll get them to introduce themselves as they go. Look, I want to start just by acknowledging the broader Ministry of Justice team who work very hard on behalf of all New Zealanders to, as part of the broader justice sector, to keep New Zealanders safe and to do the many things that we've focused on. Look, ultimately, when we think about what the government's focused on, primarily it's around rebuilding the economy. Second, it's restoring law and order. And thirdly, about ensuring that we've got public services around health and education. So in particular, the justice portfolio is a very significant contributor to that second challenge about restoring law and order so that New Zealanders feel safe in their community. Our primary targets, target 4 of the government ones, which is to reduce the number of victims of serious violent crime. The good news is that we're making good progress on that. We set a goal of reducing the number of victims of serious violent and sexual offending by 20,000, down from 185 to 165,000. The latest figure has it at 158, and so that's very promising. Of course, it will bounce around a bit more, and it's still 158,000 too many victims of crime, and so we've got a lot of work to continue.
Is that on Twitter?
In that, pardon?
Is that off Twitter?
No, so focused on that. Then we're also very focused on reducing delays in the court system and court timeliness. Very important. We don't want people waiting years to get an outcome to court cases, but also their civil disputes. And so there's a real focus on that as well. We've got a very busy legislative agenda. I just want to thank, if I may, Mr. Chairman, I want to thank the committee who has had an enormous workload, and I've very much valued the feedback from the Committee on Legislation that you've had coming through, and sometimes we've agreed on a whole bunch of things, sometimes we haven't, but I just want to acknowledge the hard work of the committee. I'm very happy to answer any questions on any topics.
Very good. Well, I'm going to lead up with Honourable Dr. Duncan Webb.
Kia ora, and Minister, and kia ora to your team. Just very briefly to start, the improvement in stats, are they publicly available? The statistics that you've been quoting for some time now, are they now publicly available?
Yes.
Of the Crime and Victim Survey?
Yes.
And you talk about a improvement, but the margin, this is of a quarterly report, isn't it?
Yes.
Yeah. And the margin for error, what's the margin for error of those quarterly statistics? Isn't it about the same size as the improvement?
No, I wouldn't put it that way.
Andrew Ray might know the precise margin for error, but there is a reasonable level of uncertainty because it's a survey-based measure. So you do it over time. We get it quarterly, but quarterly updates for the last year. So it is tempered to some extent by the fact that it's always 12 months. It's just a rolling 12 months.
Right. And there's quite a strong historical element to that. And so it's over 12 months, and the question being asked is what's happened to you in the previous 12 months. So it's a range going back as far as 2 years through to the current day. And so there is a bit of a lag to it, but we feel like we're making good progress.
More substantive in some ways. Legal aid, obviously, just announced some work that you're doing in legal aid. And I've got a number of questions around that. I guess most fundamentally, because I see you want to make it sustainable and efficient, which are sometimes alarming words. But is this government still committed to paying for lawyers for people who need them, both in criminal and non-criminal areas? And so paying for lawyers to ensure equal access to justice for everyone in all criminal matters in particular?
Yes, in the broad sense, recognising that resources are always limited, and we can't have it's not an open-ended situation, because ultimately justice, like every other part of government, such as health and education, and everybody has to live within our means as a country. We're conscious of the fact that we're still running significant deficits, and we've had an increase in debt, and so justice, like everybody else, has to live within its means. And so we think about the broader legal aid setting, and ensuring that we're getting that we're getting as much coverage and as much opportunities for people to engage if they fit the criteria as possible.
Certainly endorse getting the best value for every dollar spent on legal services. As part of the review, though, are you contemplating limiting coverage and restricting it more than it is currently?
That's not the primary focus. The primary focus is recognising, I'd love to be a minister in a government that had massive surpluses, and I could throw an extra pile of money at a particular issue. That seems to be something that we don't get to experience. But we're starting point is to say, well, we spend a certain amount at the moment, and there was an increase in in this budget in terms of investment. But how do we? It's important to regularly check the system to ask if we got the settings right. And I do note that's supposed to happen every 3 years. Hasn't happened for I don't know how many years, 6 or 7. I don't like to be critical of the previous administration, but they didn't get round to it, and we are. So we're going to.
So, okay, good. Review. Nothing wrong with doing a review. I endorse it. I'm curious in terms of, say, Crown, the provision of legal services to the Crown or the police. There's really good oversight of quality, of the quality of representation given, ultimately by the Attorney General. In terms of the provision of legal services to criminal defendants by legal aid lawyers, how do we measure whether they're getting good legal services? How can we tell that?
Well, that is a fair question, and the Legal Services Commissioner is ultimately responsible for that. But I mean, it's highly relevant in relation to our desire to speed up the processes of the courts. And I've certainly asked the question many times, if there are certain lawyers who are habitually not meeting their deadlines and not on time, what are the consequences for them? And do we just keep on? And part of that, I think, should be some discipline around that. In relation to things. So I do believe there are measures in place to ensure the effectiveness of that. But my broad observation is they're probably not as robust as they should be. And this review is an opportunity to consider some of those issues.
So there is an audit framework, but the current measure is just how many audits has the ministry done or the Legal Services Commission done. Are you keeping quality measures? Essentially, how many pass the audit and how many fail?
I'm sure they are, but can somebody?
No, there's not specific quality measures. There is some feedback given to legal services, but essentially they largely administer the legal aid payments. They make sure that they're being well administered more than the quality. But that, as Minister says, is one of the issues that you can get in the review.
Because value for money is not just cases handled, right?
I think that, Minister, if I may, I agree with that. I think value for money has to be looking at the quality. It has to look at the seniority. There's some practices where occasionally there are supervised providers, and there are some issues perhaps emerging with that through the courts. So there's a number of issues to look at around the quality framework, and we'll get to that in the review.
And look, I know there's been a bump in legal aid funding, partly because of the backlogs. What is the link here? I mean, is there an expectation? I mean, because legal aid is usually demand driven, right? You just got to pay essentially the bills as they come in for people who qualify. How is this bump in funding going to improve the backlogs that the courts are currently suffering from?
Well, it's one element amongst many, and to the extent to which extra funding is resources to meet the demand for legal aid, that'll help deal with that. Of course, the broader issue of how do you speed up the processes is a complex one, because there's not just there's a number of agencies involved, whether it's from judges through to corrections, police, the courts. There has been a tendency for everybody to blame everybody else for the slowness, and so it's a whole of government effort. And as the chief executive will rightly point out, I'm very firm on here's a list of 20 things we're going to do this year to speed things up, and when we've got through that, we'll move on to the next.
Yeah.
Can I add one thing to that, Minister? Part of what has driven the numbers in legal aid this year is actually the increased effort that's gone into the backlog. So the backlog has come down a lot over the last year. The backlog tends to be more complex cases. They tend to have higher legal aid bills associated with them. So in a way, the part of the legal aid pressure is driven by us getting through more of the complex cases. So there's actually quite a bit of story.
Thank you for that. That actually does draw a line.
Yeah.
You've seen it, but there you go. And in terms of increasing legal aid fees, is one aspect of this the government's focus on longer sentences, gangs and gang patches and so on? The fact that there are going to be, and 3 strikes would also require further advice. Is that factored into this increase? Just one of the costs?
I'm not sure specifically. There'll be sort of consequences for the system for that. But
I wouldn't want to
legal aid.
I wouldn't want to overstate how sophisticated we are. We're still working on our ability to model and project accurately in the legal aid space, but we do take account of complexity. There has been an increase in the complexity and indeed of the seriousness. So there are more Category 4 cases, more Category 3 cases coming through the system. So that is driving it, and is part of what is lifting the pressure on legal aid.
I have got lots more questions actually, but I've been told to ask one more. So actually, I was going to ask about domestic violence, but I'll save that one up.
Just on legal aid.
Yeah, this is all legal aid.
Yeah.
One of the real challenges with legal aid is remote communities, and the fact that in some places, Kaikoui, for example, busy district court, I'm not sure if there's any lawyers who actually practice in Kaikoui on legal aid. And of course, it's a Māori community, and you've got particular strategic objectives around that. How are we going to address the issue of legal aid lawyers in remote communities, and especially Māori communities?
Yeah, look, I mean, I don't deny that it's challenging, just as it's challenging to get GPs and so forth into rural areas. And
these are lawyers. We're talking about lawyers now.
One element of the solution is that will help at the margins is greater use of AV technology. But in terms of the local provision,
the review specifically calls out that set of issues. It is around the basically the sustainability of the legal aid workforce, which is, I mean, what you were identifying as an aspect of that.
Yeah.
So the review does look at that. Obviously, the challenge is how you think about the way the whole system functions, so that you can get better outcomes without a blowout in the cost of it, which is clearly going to always constrain what we do through the course of a review like this.
Okay, now, members, I want to stay on this legal aid issue. So I've got 3 supplementaries.
Thanks.
Debate.
Thanks, Chair. Talking about legal aid, and in particular the collection of debt in relation to legal aid that is budgeted for over the next 5 years, how has the debt collection increased in general, and why is it important to recover in the coming years?
well, I mean, the purpose of the legal aid is, in many instances, it is a loan. In some instances, it is a grant. But where it is a loan, the expectation is that should be paid back. Frankly, in the past, we've been somewhat modest in our approach to that, and given the fiscal constraints that we've got, we've seen a clear signal that we do expect debt to be followed up and paid. It's part and parcel of a much broader effort across the justice sector to ensure that fines are paid and outstanding reparations are paid. And in all these areas, there was very, very significant room for improvement, and that's why we're booking extra revenue in the budget from all these things. And ultimately, it's On legal aid, it's just about people paying back their loans. On the fines and reparations, it's about people, actually being held to account properly.
Thank you, that's fine.
That's fine. Right,
So,
Mr. Larkley.
supplementary, please, to this subject. Thank you, Minister and officials. Minister, as we've noted, there's been a bump to the more than a bump, increased funding for legal aid services, and that's part of the $246 million package to improve access to justice. And I guess in line with that, what we've done here, I'd like to ask you more on a legal, a factual and a philosophical basis. Why is legal aid important, Minister? And clearly reflected by the more than a bump in the budget 2025. Why is legal aid important? And do you believe that the system currently is working, the legal aid system?
Well, I don't know that I need to get particularly philosophical about it, other than to say that that our aspiration for people to have access to justice is pretty fundamental. Now, there's lots of different elements to that. You could have, if you've got access to justice, but it takes 5 years and costs too much, then it's not worth so much. And so timeliness is important, and cost is important. And so legal aid is there to help those New Zealanders who cannot afford to have access to the support that they need. And so that's important. And like I say, within the broader settings, how we control the cost of that, because like every element of society, we don't always get exactly everything we want. We have to live within our means. We set the parameters at a particular level that is broadly within our budgetary ability to cope. So we see that as important. And the whole system, of course, is interlinked, and the extent to which you can get good advice does help with the overall sort of efficiency of the regime. And likewise, the whole efficiency of the regime does have an impact on how much legal aid you need. And so if one of the big focuses when it comes to timeliness is to reduce the number of deferrals or adjournments of situations where people are sort of ready to go and then they're sort of adjourned and then they have to come back 6 weeks later, and that all costs everybody, as well as delaying justice. And so the system is very focused on trying to reduce the number of times that the cases are adjourned, and get some more discipline and efficiency into that whole system. So it's both likely to benefit from a better running efficient system as well as contributing to it.
Thanks, Minister.
Okay, I'm going to come to Mr. Sunan.
Thank you, Chair. I have a couple of questions, supplementary question on legal aid. Just for context, when we're looking at both the access to justice research in 2021, as well as, let's see, what's the other research? And also the 2023 legal needs survey, what we're seeing is 80% of the lawyers working in legal aid said that it's very stressful. 70% agree that they regularly work extended hours. Out of among lawyers who have had to turn away at least one client, legal aid lawyers are twice as likely than other lawyers. So on that premise, why has the funding, so in terms of funding in budget 2024, budget 2024 funding for legal aid only increased by 1.3%, which is below inflation. In 2025, the increase is 2.3%, which is marginally above inflation in terms of net funding. That doesn't really help us improve the actual amount. The numbers you can find on page 101 of Vote Justice.
Yes.
So how are we going to be able to increase in terms of access to justice with the legal aid when it's only just matching inflation? And that's my first question. My second question is in terms of the performance measure.
Why don't we just do that one and then we'll come back.
Well, we'll get the precise numbers too, but we've had a 25 million dollar increase in legal aid, and the previous budget was about 280 million. So I'm not quite sure where you get 2% from. I think it's
page
more
101
than that.
Total appropriation for legal aid. It was estimated for 2024-2025 at $320 million, 551,000. 2025-2026, 328 million. That is a 2.3% increase. Inflation for 2025 is 2.2%.
What page is he?
What page are you referring to?
Yeah.
101, I think you said.
Yes, 101 about justice. It is true, though, in page 103, it says a time limit increase of $21 million to address forecast legal aid demand cost pressures, but I don't know where that $21 million is coming from and whether that is the net $21 million or are we taking into the legal aid reducing fund for initiatives with low demand, which is a taking away of $14 million.
Right. Look, the short answer is that in terms of the legal aid budget overall, like I said right at the start, and I'm happy to say it again, is that like every element of government, we don't have unlimited resources, and so we set the broad parameters in a way that is broadly affordable. And you refer to the 2023 report, which is say people would like more. And I accept that, people would like more, and if we were able to spend more overall, that would be a nice thing. But we have to live within our broader means. In terms of the pressure that legal aid lawyers are under, I would like to take this opportunity to acknowledge that often people working in this area face a very, very difficult job. And as part of my role, I visit and talk to many people who are particularly working at the serious end of the criminal justice regime, have to deal with extremely difficult and emotionally draining circumstances on a regular basis. And, certainly on behalf of the government, we want to acknowledge those efforts and thank them for it, and recognise that, yes, it's not, we can't solve every problem with unlimited funds, but so what we can do is ensure that the resources that we do put in are designed to achieve the best potential possible outcomes, and so that's what the purpose of the review is.
And I can explain the numbers now that I'm on the same page. We actually put through an increase in supplementary estimates for the current financial year that's just finishing of about $23 million, and then there were about $25 million for next year. So it's a much bigger increase, and it just started earlier than 1 July because we needed to bring some of it into the current financial year.
Okay.
So it is about a 10% increase based on what was previously forecast.
What was your second question?
My second question is on page 102, when it comes to number of legal aid cases granted, I did see that the budget standard for this year has not increased from last year. Are we expecting the same number of people will have access to it, which means that if there's an increase in demand, we're going to see more people being rejected as being part one. Part two is estimated actual for 2024, 2025 is at least 62,000, which is very convenient because it meets the bare minimum of the standard that the performance has set itself. But at least 62,000 could be 62,350, or it could be 2 million. What's the exact number of at least 62,000?
Well, I'm afraid you've bamboozled me. I couldn't follow that.
Maybe I can answer the way we do our forecast for legal aid is we do look at what we see the projected activity is, and then we will make a series of assumptions around what is the likely level of number of events and the likely cost per case, and we factor that in. And essentially, the earlier comment made that, I think by Mr. Webb, is that it's largely demand-driven is true. So we do have to go back and have a discussion with the Minister of Finance about needing more funds, and questions will be asked as part of that. But the government has recognised that when the demand goes up, you need to increase the amount in the legal aid budget. And to a degree, that's what you see in these numbers here. It's recognising that there is a demand increase. It's not the number is it's a forecast in terms of the legal aid budget as opposed to a target. That's just what we expect the numbers will be.
This is the estimated actual for 2024, 2025 in here as though, because we see quite often in vote justice in terms of the actual meeting the target. And I'm anticipating that for what you're planning on doing next year, what does at least, because it's not actually the target that you're setting itself. This is the actual amount in terms of the number of people who've been granted.
Sorry,
This is page 102.
102.
Yeah.
It's not seen as 102.
I think that's the part where I wasn't quite sure if you were, what part of that band you were expecting.
This is in the morning.
You know the answer.
the numbers of people who embarrassed, how many people we get legal aid. Well, they're looking at that. I mean, the broad point.
We could also submit as a post-hearing
But
question.
my pay just in terms of, being able to predict the number of people that are going to need it in the next year is obviously an estimate, and it's hard to predict perfectly.
Was that?
Well, that's simply, you're absolutely right, that we
Do you want to
expected.
respond in a written question?
Yeah, I can.
Let's do it in a written
We could,
question.
I mean, the answer is we estimate there will be 62,350. We've said at least that, so it could be slightly more.
Okay,
That would be
let's
the
do that
extent
in
of
a
it.
written
Okay,
question.
thank
I'm
you.
going to take one more question on this topic and then I'm going to come to,
Kick it off. I'll be back though.
all right, so I'm going to, oh yeah, she did.
Well, mine's-
Mr. Stevenson.
Yeah, mine's a supplementary, maybe it's a clarification.
Yeah.
Obviously, you've done a projection, an estimate of 62,000, but there's no cap, is there?
No.
No. I think that's the answer, right?
Yeah.
There is
Yeah,
no cap.
That's what, there isn't a target or a cap. That's
No.
what we expect.
Yeah, you've just done your best to
Yeah.
forecast that. Thank you.
Done? Right, now we're going to start a new line of questioning to Mr. Ferris.
Okay. And I'll have-
Kia ora. Tēnā koutou, te minita, tēnā koe, Mr. KiwiPulse. Hey, well, just a simple question for you. We've had a look at your budget and there's not much in it leading forward for Māori solutions, despite the fact that this remains a cornerstone of what you seek to achieve. Better justice outcomes for Māori and addressing the overrepresentation, so on and so forth. And it just strikes me that over the last couple of the days that we've had, that there just seems to be a real reluctance to either describe the problem or commit to the problem and put on a line on a piece of paper how much money you're going to put to it. So my first question for you is, what new money are you investing into Māori-led solutions to help reduce the overrepresentation of Māori in the justice system and provide better outcomes, justice outcomes for Māori in the system? What new funding do you have?
Well, I'd start by, I suppose, making the obvious point that we don't sort of agree with the proposition that the only way a system can help Māori is through specific programs specifically for Māori. The starting point is that Māori are more likely than other New Zealanders to be victims of crime, victims of violent crime and sexual offending in particular. So everything we do in the justice sector is designed to reduce the number of victims of crime. And that is designed to help and reduce the number of Māori victims of crime as well. So when I think about how can we improve justice outcomes for Māori, that is the primary focus of it. So everything we've done from restoring real consequences for crime, making sure that we have fewer victims of crime, and the obvious place to start is with that small group of New Zealanders who are creating multiple victims of crime and holding them to account and actually, frankly, take them out of circulation for longer is the best thing we can do for Māori as it is for every other New Zealander. In terms of specific programs, you're right. The previous national government brought it to old Marama court projects, and the previous government expanded that. And we have maintained our funding in that area through the budget. What we haven't done is significantly increased it at the scale that the previous government were proposing to do, for two reasons. One is that we have frankly a tougher financial environment, and we have to sort of be mindful of that. But secondly, we wanted to take a little bit more time to measure the outcomes of the ones that were started before we roll them out, and we think that's a very sensible thing to do there. And we're happy to sort of the chief executive might have put some further detail in. So my primary answer is everything we do in the justice sector is designed to have better outcomes for all New Zealanders, including Māori, who are more likely to be victims of crime than other New Zealanders.
Just quickly in response to that, reducing Māori victimisation is a future proposition.
Yep.
So what are you doing? What's your plan for the current and historic state?
Well, Well, the best thing, well, yes, but we can't control what happened in the past, but we do have a ability to influence what happens in the future, and so that is very much what we're focused to do. If to the extent that we've reduced the number of, every 1,000 fewer victims of serious violent crime that we have in the next month and next week. Is 1,000 families that not sort of turned upside down and destroyed, and to the extent that they have been. So that's what our primary focus is on.
So no dedicated funding to addressing current situation, or maybe Mr. Kibble has a view.
We have a number of programs that are looking to find out what is the best specific solution for this community. There's a program called Whakorangia Te Mana Tangata that we have been running in a couple of courts, and that is actually working with local providers to ensure there's a wraparound care for people as they come out of the court system. And so it might be that they may be doing something as simple as providing a bail address. They may be helping coordinate some of the rehabilitative services around those people. And we continue to look at some of those, and some of those are based on iwi organisations, and we're looking at other community sort of bases for those sorts of issues as well. We haven't increased the funding into that area, but we've carried them on, and then they are being evaluated with a view to, is this meeting a need for a particular, is this the most effective way of meeting a need for a particular population group? And clearly Māori is a population group with a higher levels of offending and the like, and there's a greater need there. So we're still, we have license to look at those sorts of initiatives and to keep doing work in that space. Te Ao Marama is one way that comes forth. Te Ao Marama is not just about working with Māori, it's about working with community more broadly. But within that, if you're going to do that, you will have relationships with iwi and with other providers in the local community to try and take it forward.
Yep. So fairly baseline activity. We do note that there's been a $450,000 reduction in the funding of Māori-led whānau and community wellbeing initiatives. So we're talking about baseline activity as your drive to deliver better justice outcomes for Māori, and in an environment where you're actually having reductions in targeted kaupapa Māori delivery funding. Is that the best that we can commit?
There's an effort that goes, yes, across all our baseline activity, as how the Minister explained it. We are looking to ensure that they're going to work for Māori. Within that, we have a number of programs.
What's the historic success rate of that? You're looking to ensure that existing programs deliver for Māori. What's the historic success rate?
I think some of that.
Does it need new funding?
Well, some of it's mixed, but if extra money was the solution, we would have had great success over the last few years, but we haven't. And in fact, what we saw was things getting substantially worse. And so, look, it's always a combination of messaging and the signal that government sends. And we had a different signal from previous government, and that's a philosophical difference, which was around a focus on reducing the prison population, a focus on what might be called the background of offenders, and we've shifted that focus to a focus on reducing the number of victims of crime. Now, we think that's the best thing we can do for Māori and for all New Zealanders. And in terms of overall funding, yes, everything is tight.
Yeah, I've got a question. Any more? You're right. Right, I'm going to go to Mr. Bade for a supplementary. We're just going to continue on this slide.
Thanks, Chair. Given this is in connection to iwi and working with iwi at a local level, I thought it's the appropriate place to ask progress on the Te Puna Hapori Wanganui Courthouse spend over the course of the next year.
Well, we can give you a bit of an update on that. There is progress, but the exact sort of nature of it.
I get Kelvin to talk specifically to it.
You've gone into Courthouse. I don't want to go there. I want to carry on this topic that we're talking about.
It's related to working with iwi at a local level, so context.
But I'm sure we're going to have a whole lot more on infrastructure, so we might just park that question. You can take your next up.
Cool, thank you. Tēnā koe te minita o tēnā koutou katoa. Following on from Takuta's line of questioning, we've talked about outcomes for Māori, but is there any work being done on quantifying the value of these kaupapa Māori programs, like you've mentioned, such as Te Ao Marama, such as Mauri Tūpai, and the benefits that they have not only for Māori, but non-Māori?
Yes.
Because having gone throughout the electorate, so what work is being done to quantify the value of these programs and therefore justify future delivery and funding? And because you mentioned iwi, are there any specific plans underway for devolution of programs to iwi or hapu?
Well, the answer to the first is yes, and we can, in terms of, I mean, that's very much the point that we are taking stock of Te Ao Marama, for example, and there's a process underway to work that through. It's it's not something you can do overnight, of course, because if you're thinking about more effective rehabilitation and therapeutic processes, it takes a long time to be able to demonstrate a change. But that's a very important part of it. Yep.
And it is underway. You are actually.
Yeah, we're certainly reviewing some of the dimensions of Te Ao Marama. So there's a young adults list court, which takes quite a different, more therapeutic approach, where we have a review and evaluation underway as to quite a few dimensions of that. What impact does it have on timeliness? What impact does it have on reoffending? How enduring is that impact on reoffending? And so that will be able to tell us a story that means we can assess not only what's the immediate effect of this on the efficiency of the court, but what is the likelihood of us getting better outcomes for the people who go through it? In the Whakaorangia Te Mana Tangata program that I talked about before, that's probably where we're closest to devolving more, and that we've engaged with an iwi provider to receive people as they come out of the court and to provide more wraparound care. We've had the Impact Lab evaluating that, and we have other evaluations underway for that program as well. Again, that's another one of the components you would bring into a Te Ao Marama court space. There's some things about how you actually run a different court process, and there are some parts of that which go, how do you draw in the community providers, or indeed just community kind of social networks, to help people basically onto a rehabilitative pathway. And we are quite rigorously looking to evaluate all of those sorts of things so that we can provide the advice that the Minister anticipates with what should happen with Te Ao Marama.
And there's definitely the intention of devolving more of these services to iwi.
I think I mean, the intention is we're interested in what works.
Yeah.
And it's a fair comment, and it's a comment that Mr. Ferris was making as well, that in terms of rehabilitation programs, for example, and the ability to get people sort of back leading productive and safe lives in the community. We spend a lot of money on that across government, across many areas, and it's pretty mixed. And so there is an enormous opportunity to do better, in the extent to which iwi providers or other community advisors can present a compelling opportunity to deliver better quality services with better outcomes. We're very much interested in that conversation. So that is a real opportunity.
Thank you.
Right, Lawrence?
Would you like
Could you hit a supplementary on?
I do have.
On that.
I have a couple of on that. I think the first one is, we've been talking about Te Ao Marama. Te Ao Marama's review is due in 2026, but why has $32.1 million of tax contingency funding been pulled from Te Ao Marama now, when it's still in the process of being reviewed? I hear what the Minister just said, that we're looking for things that worked, but we actually haven't had the chance to see how Te Ao Marama is going to work.
But simply because the previous administration, previous government had more and more Te Ao Marama courts opening up over the next couple of years. And so what we've done is pause the new ones coming in until we've had the chance to do the review. And then if the review comes back and saying this is a slam dunk, it's working brilliantly, then we'll ramp it up again. But we just wanted to take some time to do that review first.
Cool. Thank you, Minister. You've mentioned before that, just also before, in terms of some of the work that's been done in terms of analyzing what is going to be good for particularly, let's say, Māori, because Māori is overrepresented in the justice system, as my colleague Dr. Ferris has mentioned. But what we have seen over this last year, for example, is legislation being introduced, and I can name three: the reinstating three-strike legislation, the gang legislation amendment bill, as well as the sentencing reform amendment bill, and the introduction of section 66, 2, 3, and 4 of the Crimes Act 1961 as aggravating factors, i.e. party liability. all of those will negatively affect Māori in terms of their ability to not be part of the justice system in the first place. So as part of your research into this, are you also factoring in the impact of the legislation that has been introduced on more Māori entering the system?
Well, I feel I just don't agree with, yes, all of those things will negatively affect Māori offenders, but they're designed to benefit Māori victims of crime. And our primary concern is with the victims of crime. And so that's what we're focused on. And so I don't agree that overall, for overall Māori, that any of these things are negative. Yes, they are negative for perpetrators, but ultimately, we believe that people should be held to account for their actions. But our focus is on the victim of crime and to reduce the number of victims of crime. And so you rightly pointed to the sentencing legislation, which will be taking effect in a couple of weeks, which limits the ability of judges to massively reduce discounts. They still retain their discretion to make up to a 40% reduction, including for guilty pleas. But we weren't comfortable with the fact of people being convicted for serious violent offences facing discounts of 60 or 70%, and with the result, society not sending a clear message denouncing a particular act, and also not keeping the community safe from those offenders.
I understand that, Minister.
I'm going to take two more on this topic.
Yeah.
I just remind people, everyone, this is about estimates. Dr. Webb.
So in terms of, the work going forward, and it's still on the strategic priority of improve justice outcomes for Māori. And I guess my question has two limbs. The first is, and Minister, you've said on several occasions now that you've got to focus on victims. And it's quite difficult when reading the strategic documents to find out what good justice outcomes for Māori are and what bad ones are. It presumes that they're bad at the moment. Are you saying that you're not particularly interested, for example, in the conveyor belt of Māori that are getting in trouble as rangatahi, going to the rangatahi court, and so on and so forth, and ending up in prison? Because that's a justice outcome for Māori that I'm deeply concerned about. And I guess, so that's my first question. What is a justice outcome for Māori?
Of course.
And then the second one
No, let's just do that.
Yeah, well, of course I am concerned about conveyor belts, but I mean, if you start with a starting position, which we start from, how do we reduce the number of victims of serious violent crime? If that's your starting proposition, there's lots of different elements to the answer to that. First and foremost, you've got to restore real consequences for crime, and that's the tougher legislation side. That's only one part of it. The second part of
what does a justice outcome for Māori mean? That's the question. Yes. What does it mean in the strategic document?
Well, what it means,
as it relates to,
first and foremost, it relates to better outcomes for Māori being less likely to be victims of crime. And that's a primary focus. And how you get there is, like I say, restoring consequences, but also being much more effective in the various interventions we make across government on the therapeutic side. And so one of the things that the government did was, of course, enable rehabilitation programs to occur for the prisoners on remand. Another area that we work on, if you're thinking in youth justice, one of the real drivers of that conveyor belt of crime that you referred to was the hopeless response we've had in the past to truancy at school. And so we're a government that's very focused on doing that. The number of young people growing up in emergency housing, for example, has been a part of that conveyor belt. And so as a government, we're focused on reducing the number of those. So there's a whole broad range of efforts made right across government to deal with both the drivers and backgrounds and broader social factors. But we're always very mindful that if you just do that on your own and create a culture of kind of excuses for crime, then you've got a real problem as well. So you've got to also have a clear set of consequences for crime, which is the other part.
Okay, last question from Mr.
Yeah, that was the first part.
I thought you had a second part. All right.
Because the second part is this, and it may, how do we know if we're making progress? What genuine measure, what objective measure is there that we're making progress? Is it simply that your crime and victim survey says there's less Māori victims of crime, or is it about how many Māori are in our prisons and so on as well. Who's measuring this stuff?
Well, the primary measurement is yes, it's precisely that, a reduction in the number of victims of crime, including Maori victims of crime. And to get there, of course, as you say, how do you get there? And the good news is that after 18 months, we've made significant progress on that, and we've got more than 28,000 fewer families broken by violent crime, but there's still far too many who are. And so we want to drive that down. Because that's the sort of the overall target. How we get there is that combination of stronger consequences and also more effective intervention to change behaviour. And both of those are equally important.
Right, last question
And we
from you,
measure,
Mr.
if I might just add to that, we do measure those things for Māori as well as for the broader community.
Okay, good. Last question from Mr. Ferris on this.
Kia ora again. I really want to just step out of this questioning and scrutiny and digging and everything that's going on here.
As long as we're in
and-
estimate, we got to do it on
Right.
estimate.
Every part of this question has to do with how you're spending the money to achieve the result.
Yep.
So it would appear to me and most observers that Māori seems to be the most significant current and long-lasting problem in justice. And so we've heard from police, corrections, status quo, keep going, no target, no determined, intentional funding. You have a significant role to play in the leadership of a sector. What's it going to take to address these issues that Māori have historically and without a doubt will in the future continue to face? What's it going to take to change that, and how long do you believe it will take?
You're asking me that question, or
Both of you.
look, I think,
I think I'd like to hear from Mr. Kibblewhite because he's got his hands on the steering wheel, but
I'm not. I mean, there is a. I'm glad you think that, but it's all part of a broad.
he's the CEO, isn't he?
Yes, and the way that our system works is that ultimately the ministry and the executive and the cabinet are accountable, and that's one of the great joys of living in a democracy is that every 3 years the people get an opportunity to throw us out. They don't think like we're making progress.
So what do we need to do to change it, Minister?
Well, to make progress, like I say, is to reduce the number of victims of crime. And the good news is we are making progress, and there's a lot more to do. And look, I think sometimes we sort of I think overemphasize the differences, but I think there is widespread agreement across New Zealand that it's a combination of clear rules and enforcement of those rules and consequences, but also an ongoing effort to deal with some of the broader social factors that are associated with crime. And that's why, as a country, we invest colossally in housing and welfare and education and all those things. I suppose the difference between us from a political point of view is you seem to be implying that the only way you can really make progress is specific Maori focused programs, and that's the only evidence that you care about the issue. Whereas I'm making the point, well, yes, we have some of those, and we continue to invest in those programs. But broadly speaking, the sorts of things that the average Māori person are concerned about, that is living safely in their community and not living in fear of gangs and not living in fear of violence, living in a household where they're not living in fear of domestic and sexual violence, is the same as every other New Zealander, that they want to be safe from those things. That is the core of our justice strategy and what we're focused on.
Okay, all right. Thank you for that. Now we're going to move to a new topic, a third. Mr. Rutherford.
Thank you, Mr. Chair. My question's around the Ministerial Advisory Group for Victims of Retail Crime.
Yes. Yes.
Firstly, can you tell me about what's next on the agenda for that Ministerial Advisory Group, please?
Well, I've been very pleased with the progress made. So in the context of that, we have been obviously very focused on and concerned about the uptick over the past few years in retail crime. We had a very significant increase in retail crime over the past few years, with ram raids being a kind of a headline feature of it, but it was much broader than that. The good news is that ram raids have reduced significantly from a combination of things, and that's good. But there's still an ongoing challenge with retail crime more broadly. Yeah, exemplified, I think, from things that I'm sure all New Zealanders would have witnessed and seen, of a big increase in people walking out of stores with stuff that they haven't paid for and no consequences for it. People walking out of supermarkets with trolleys full of food, surrounded by security guards and police sort of escorting them to their car and watching them as they put them in the car and drive off. And it's a hopeless state of affairs. So the Retail Advisory Group was designed the primary reason being that, as you'll all be aware from people being on the committee, the Justice program is extremely busy. And there's a lot going on. There's a lot of policy work going on. And we want to do more things than the Justice Policy Advice Team could possibly cope with. And so we brought in the Retail Advisory Group to provide another means of grounds or area where new ideas can be generated. So the first and foremost was, and what will happen is that we'll be introducing a crimes amendment bill soon, which will address some of the things that I've talked about. So first was giving clarifying rules around citizens' arrest to enable, and it'll probably be in most circumstances, security guards to hang on to people and detain them until police are able to come and without being sort of accused of assaulting somebody by holding on to them. And then secondly, we want to deal with low-level shoplifting offences at the moment. That the consequences for those are pretty thin, and so we want to come up with a simpler regime there. Next cab off the rank is looking at the trespass legislation to get that working more effectively. And then the fourth area is around facial recognition technology, and you'll all be aware that the Privacy Commission has been looking at that. We want to end a certain sort of level of facial recognition technology has been given the broad tick of approval in terms of the privacy law, and we want to sort of test whether there's not more we can do. We want to give retailers all the tools that they can to keep their people safe, their customers safe, and also to send a very powerful message that we're not going to put up with people stealing stuff all the time, recognising that it's the law-abiding citizens in New Zealanders who have to pay more for their stuff if that happens. So that's very much the focus, and I'm very pleased with progress so far, but there's a lot more to do.
On the Ministerial Advisory Group for Victims of Retail Crime, would you say you've been satisfied with their performance and value for money? Or would you agree with a recent comment from the Honourable Ginny Anderson, which said instead of focusing on real solutions, the government has wasted millions on an advisory group?
How is that estimates related?
Well, there's an
money.
appropriation in the budget of $1.8 million budgeted for the Ministerial Advisory Group over
And
the coming financial year.
Well, I'm not really interested in the view on Ginny Anderson.
Well,
But I am interested in the first bit.
Minister, maybe.
Thank you, Mr. Chairman. The good news is that $1.8 million comes from the proceeds of crime fund, and so it is the crooks who are paying for it, and that's a good thing. So we've made good progress on that. The second thing is that I think it is they are delivering good value for money in that respect in terms of generating good quality ideas. Now, we don't necessarily agree with everything they come up with, and when we introduce the legislation, there'll be some things that you as a committee will look at and you'll say, well, I don't know about this, and we're happy for a discussion to be had about these things. And we recognise there's a variety of views, and that's the beauty of the select committee process.
You got another question?
I was going to ask about steps taken to address low-level offending and other forms of retail crime. So you've talked
Is that in
about
retail? And retail, that's the last one.
Yeah, yes, it is.
Well, that's the sort of second area that I've tasked the Ministry Advisory Group to come up with some advice. They have come up with some very good proposals that Cabinet is in the process of working their way through, and we'll be able to announce the exact details of that hopefully in due course. But our goal, as I think in the second quarterly plan, is that right? Second quarterly plan is to get an amendment to the Crimes Amendment Bill in place, or ready to be introduced, and we're broadly on track for that.
All right, now I've got a number of supplementaries. First of all, Mr. Chino.
Thank you, Chair. Can I just get a clarification from you first, Chair, that are we also now expanding to
No,
discuss
we're
beyond
talking about
estimates
the
to
estimates.
crimes of proceeds fund?
That's part of justice, isn't it?
Well, it is, although it is
Because it's not estimates.
But
strictly.
I don't want you to go into a new, we were talking about retail crime, so
Cool,
I'd
great.
rather you continue that before we open up a new topic.
Sounds good. I guess on the subject of what is being worked on in terms of citizens' arrest, what I'm not seeing in the budget or in the supplementary budget was any line on that. Would you be able to identify? I have two questions. So this is the first one. Would you be able to identify where I can find any sort of even tag contingency on anything to do with citizens' arrest in the budget?
well, no, it's part of the broader.
The short answer is no, because it gets absorbed. Some of the policy group has provided advice on it. There will be work that inevitably comes through police and courts. It's not
I
additional.
think we
funding.
heard that.
So it's not additional funding. Okay. Second question is.
It fundamentally doesn't cost the taxpayer
Right,
for somebody
anything.
to detain somebody walking out of their shop until the police arrive.
Again, that actually, thank you, Minister. That leads very nicely to my second question is, with things like that, you will also need to have educational programs. And also in terms of liability, let's say a citizen gets hurt in the process of that, who is liable?
Well, these are things that every.
We've got to keep this back to the estimates, guys.
Yes.
So let's just have it.
The estimates
I'm
would be,
very happy to give
should
a sort
there
of a-
be a tag contingency for liability?
But he's
in-
already, the minister's already talked about it, some policy and development.
Well,
So
I'm very happy just to give a sort of a high-level answer, which is to say that the legislation that we're intending to pass in this space is an enabling piece of legislation. It doesn't tell anybody that anybody has to do anything in particular. And so every individual and business has to make a judgment as to whether, what their sort of rules are, and that they're responsible for them ultimately.
okay, Dr. Wood.
So, Mr. Rutherford mentioned the 1.8 million. $230,000 of that up to is Sonny Kushal, and he got $180,655 in the last year, but remuneration paid to the members, other members, was only $4,658, which suggests that the whole show is Sonny Kushal. What's going on there? Is this just Sonny Kushal with his reckons, or $230,000 a year plus the ministry's support at 1.8 million, or is it the actual other members being engaged?
Do you want me to speak to that?
Oh, well, you can.
A number of the members aren't claiming reimbursement, so that's why the numbers are like that. So they're entitled to it, but they're choosing not to claim.
But
And I'd just like to say, I'd like to thank them for their public service.
but they are
Very good.
Yes, they're choosing not to claim the money.
Pardon?
Yes, they're just choosing not to claim the
There
reimbursement.
is a difference in the roles. So the
Yeah.
chair is much closer to a full-time role, and he is but he's got an advisory group around him where they test ideas, where they commission some work from other parties and places.
Yeah, at 180,000, you'd think it would be pretty much full time?
Yes. Yes.
Yeah, okay.
Yeah, he's effectively an executive chair, and ultimately, like every element of the system, highly accountable, and they're delivering good outcomes so far, and we've got to keep it that way.
Right, Mr. Stevenson.
Thank you. Just sticking with the topic of retail crime. Minister, you mentioned kind of four things that you were looking into. The one was around trespass legislation. And I've met actually with a number of retailers, and it is a bit of frustration when they do trespass people, and then it's not really, no one takes any notice, etc. Can you just, obviously the ministry's policy team are going to be beavering away over this in the coming year. Just top line, what are you envisaging around doing trespass to try and make it a bit more effective?
Well, look, again, the final policy decisions haven't been made, and when the legislation is introduced, we'll go into greater detail. But the top line, the goal is to make a more easily functional system. At the moment, the feedback that we've got from the broader community is number of people struggle to make it work. If you've got an extremely well organised regime, you can make it broadly work. But most people are just trying to sort of keep their business alive, and they just want to stop people causing mayhem on their community. And so we want the system to work more smoothly and easily.
I think that's the feedback I've received. So I think that'll be well received. Thank you.
Right, we're going to a new line of questioning from Lawrence.
Thank you, Chair. My new line of questioning is around the appropriation, which is community justice support and assistance on page 113 of Vote Justice. Understanding that there is part of the supplementary budget, what you're seeing is a sufficient decrease in terms of the non-departmental output expense for community legal assistance, down $37 million. Well, $37.615 million to be precise. Why is that?
Okay, let's get a high
I
level.
think, my CFO is just finding the precise numbers. I think it'll be to do with the special fund. So that's actually just monies that are made available through the trust accounts of real estate lawyers. They're provided to the Treasury, and then it's up to me as Secretary of Justice to disperse them to the community law centres, which I do according to a budget. So that the fluctuation in the numbers is actually primarily a consequence of how much money is flowing into the fund from real estate. So it's a slightly convoluted arrangement, but essentially we support the community law centres with those funds first.
I understand that there are an extra $28 million from the Lawyers and Conveyance Special Fund allowance as a part of 2024-25.
And what we do is we roll that forward. So that money has to be used for this purpose.
Yep.
So it can't be used for other things. But the way we achieve that is by the money comes to us, we then roll it forward to the next year with the Treasury, and then we will disperse those funds to the community law centres in the next year.
So that then is the reason why, even if you're looking at the community law centers funding specifically this year on page 115, we're looking at service provided for multi-category appropriation, it is still lower than last year because of that rollover.
Well, it's lower than
Yes.
Good afternoon, Andy Fulbrook, CFO. What happens is we collect the money in 2024-25 year. Once we know how much we've got, there's an expense transfer which is carried out, and the next year, which then brings the extra money into our appropriations during October, November, later this year. So all that, as our CE said, all of the money that comes from that special fund can only ever be used on community law centres.
Can I also check, final question, Chair? On page 114, when you're looking at the performance assessment, it talks about total number of victims supported, and it's still using the same sort of figure as at least 35,000, which is the estimated actual, not in terms of estimates. The estimate is 35 to 41,000. Will we please have access to the exact number? And also, is there planning of a performance measure which talks about how many people they will need to reject? I think it's great they supported this many, but is that many people is all that is required in terms of the number of people supported, or it's far greater, and therefore we should be looking at a greater level of support for community law centers?
That will be our best estimate of the level of activity that will go through the community law centres. But we can, if you'd like a more precise answer around the forecasts and what our expectations are, we can do that.
Okay, we might do that. You finished that? Right. Well, I'm going to Mr. Bate for a new line of questioning.
Thanks very much, Chair. I want to move to court timeliness and operation. The budget provides over $446 million over the next 4 years to improve court delay and improve access to justice. Why is it a priority for the government to speed up court delays and improve access to justice for victims?
Well, I mean, look, the obvious reason is that very long delays to justice have built up over the past few years. COVID made it worse, and as a country, we're struggling to get that back into an even keel, and so people can be waiting years for their criminal cases to be dealt with. And of course, if you look at it from the point of view of victims, which is what we're focused on, if you've been a victim of a crime And then years later, you have to go back and relive the whole experience. The longer that is, the longer it is before one can get closure and move on. And then if there's an appeal for that, it might be another couple of years. The longer that is, the more people's lives are dragged out. I was talking to the parents of a murder victim last week, actually, for victim support, and you see very firsthand the trauma that family experiences from the proposal of an appeal and years to come. So getting that system working effectively allows people to move on with their lives. Of course, another big part of the justice system in the civil space is people trying to get their arguments resolved. And if it takes too long to do that, well, quite often people just opt out of the court system, and if they can do that and solve things through arbitration, well, that's all well and good, but we should have the ability for people to get their disputes resolved in a timely fashion so they can move on with their lives and continue to invest. So all of those things are important, and in the family court setting, likewise, endless long battles have a huge impact on the family. So that's why. And like I say, it's not a simple solution because it's a complex system with lots of different players. We have the constitutionally independent judiciary, and they have an impact on it. In the criminal space, corrections, police, and the courts, and all part of the solution, and so a part of the dealing with the issue. And so partly it's a legislative response. There are some things we can do to change legislation to speed things up. Some part of it's how you get the infrastructure working effectively, and there's enormous opportunities through better use of AVL, for example, and not in every circumstances, but in some circumstances. And if you just think in simple terms of if rather than having four lawyers driving down from Auckland to Hamilton and waiting 3 hours in the court case in the room for a court case, in terms of the legal aid costs and everything, time costs, whereas people have been able to do their work and just log into a electronic thing from their desks in Auckland, that there are colossal productivity gains if that is advanced quickly. So there's a lot of efforts going into that. I mean, the biggest thing that we're focused on is the digitisation project, Te Aotearoa. Most New Zealanders would be shocked and horrified to know that the court system, in many aspects, still works on people scribbling things down on pieces of paper and carting large files around in trolleys. So we're trying to change that, and so we'll be starting with the family court next year. If it goes according to plan, which is very much my hope and expectation, that will be transformational in terms of the productivity of the courts and open up a whole new range of possibilities for a faster movement. I don't know if there's anything you wanted to add on that.
Thanks, Chair. So how does the spending initiative relate to the government's priorities and targets in the justice space?
Well, in terms of the target in terms of reducing the number of victims of crime, it's tangentially related to that. And in a sense, I mean, one of the fundamental issues that we've got is nearly half of the people in prison in New Zealand today are remand prisoners, that is people still waiting for a trial or for sentencing. And that's a function of a whole heap of things, but partly it's because of the delays in the system is one element of that. So to the extent that we can improve that, extent that we can get people through the system better will help. But another target that we have as a government is to reduce those delays in the court system. At the district court level, they've set goals in terms of 90% of cases being dealt with in a sort of an agreed time frame for different categories. Where I think we're up to 81% across nationwide, and my very strong encouragement to the whole sector is to make is to continue to make progress on that, because that I think is one of the most useful things we can do for victims of crime.
Could I add one thing? I mean, the other government target that I think the court's role is often understated in is the economic growth one, and in terms of underpinning prosperity and confidence of decision makers, how the civil jurisdiction in particular works is really important. And if you look over the last year across the District Court Civil and the High Court Civil, we've made some really quite significant changes, improvements in getting work through the court more quickly and getting the number of active cases down by disposing more of those cases. So it's one of my bugbears. I think people don't think of the courts and justice as an underpinning of prosperity and growth. And I think it absolutely is.
No, but any more questions?
Point.
No, right. I've got three subs. First one from Lawrence.
Thank you, Minister. Actually, I got two questions. The first
I
one.
think we only gave you one, but just do your best one.
I will do my, oh, no, the other one is good. My first question is, I understand that there's additional funding towards the Tauranga Courthouse as well as the Auckland District Courthouse. What is the rationale behind not funding for the Rotorua District Court, High Court, Rotorua Maori Land Court, and the Waitakere District Court?
Well, we want to do all of those things. It's just a question of timing and funds being available. And I appreciate the Greens have a different approach when it comes to fiscal matters. We are very superior. We are very conscious of the need to live within our means, and we are worried about the overall sort of debt increase that we've had as a government over the past few years. And so we're being very careful and about big capital, new capital investments. So we want to do those things as quickly as we can, and we're as part of an ongoing conversation with the Minister of Finance is at what point can we make some announcements in that area. And we want to provide as much certainty as we can and get on with it. I think it's a fair criticism, not just of the previous government, but of many governments beforehand, that we haven't paid as much attention as we should have to the quality of the buildings in the space. And so we've got an extremely significant program underway. I think if you thought of the last 30 years, there's probably never been a time when there's as much work going on in the justice and court space in terms of actually building new quality projects. So, and we want to do even more, but we're just having to be.
So we've got the Minister of Courts on Thursday.
That segues very nicely to my second question.
Well, we've got courts on Thursday, so.
But this is part of Vote Justice.
Right, last question.
Okay. That segues very nicely to my second question. Is the Ministry of Justice exploring PPP options for new courthouses?
Yes.
Right. Supplementary, Honourable Damien.
Look, thank you very much, and I'll keep it at a high level because it's about the performance of the justice system. So I don't want to get bogged down in the details, Minister, because you'll have to refer those on. But one area, and Secretary Kibblewhite, he referred to one area of growth, or the obligation growth. Very strong growth in the prison population projected. I guess that's one growth area the government might be proud of. But if as your previous boss, Prime Minister English, was to say that actually prison populations is a moral and fiscal failure, then the 4,000 extra prisoners that you're projecting to have to build prisons for and service and look after by 2035 is a measure of the failure of the system. The question is, that massive amount of money that will be required, do you consider that there are ways you could spend that money now to reduce that prison population in the future? And if so, what would they be?
The first part.
As far as it relates to your
well, can I, Mr. Chairman, I appreciate it is stretching, but it is actually referred to, the prison population report.
Yeah, I know that, but we had the Minister of Corrections yesterday.
I'm happy to answer in the sense that ultimately corrections is the estimate sort of side of things, but decisions that we make in the justice space, in the laws that we pass, have consequences for that, and we're very conscious of that. And we think the first duty of any government is to keep New Zealand citizens and people who live here safe, and our first duty is to ensure that people feel safe in their communities, and so we explicitly change what the previous government's focus on was reducing the prison population by 30%, irrespective of what was going on in the community, to focus on reducing the number of victims. And if that means in the short term we have more people in prison, well then so be it. we don't want to have more people in prison, and we don't have a goal of increasing the prison population. But it has to, but it has to respond to the level of crime in our community. And so the projections are based on a steady state, but all predictions are by nature of things based on estimates. Our goal, of course, is to amend behaviours and to change people's activity, and by having fewer victims of crime, ultimately there will be fewer perpetrators of crime. So that's our focus. But if it means that we have to spend more on prisons in the short term, we're prepared to do that.
Minister, I was asking quite specifically because you've referred to a number of positive initiatives, you say, in justice that should help hopefully reduce crime, which you say, and reduce ultimately the prison population, which would be an outcome. Where would you spend the money or more money to actually improve or reduce that 36% increase in numbers, which is pretty horrific?
Yeah, it is. Look, I think a starting place is it's not necessarily more money, but in the broader efforts across government around rehabilitation. And if you think of alcohol and addiction and whole sexual behaviour, violent behaviour, I think an ongoing challenge for the government is, and if you look at a lot of those programs inside prison and outside of prisons, the success rate is, some of them are very good, some of them are very modest. And so a real focus is on ensuring that we get the best outcomes from those, which may well be, and we continue to have conversations with a range of providers in that space. So that, I think, is the real opportunity.
Happy? Right, we're going to Mr. Rutherford for a new line. I'm coming back here.
Thank you, Mr. Chair. My question's about the electoral system and the 4-year term referendum. Budget 25 firstly provides funding for the Electoral Commission to maintain electoral system performance and funding for integrity improvements to uplift electoral system performance. What will that funding do, and why is it necessary to begin with?
So there's two different elements there. One is the increase in the spending on the Electoral Commission, and that is because fundamentally there's more people, and secondly, there's a huge need for greater use of technology in the broader settings. There's also been, for example, an enormous amount of stuff that has been done by mail, and the cost of mail has increased significantly, and so there's pressures there. Now, part of the solution is maybe not needing so many things to have to go through mail, but so there's a broad range of things there. But I think if everybody looking back at the previous election, there were areas that we weren't at all satisfied with, and such as it taking 3 weeks to get to a final vote, and also some lapses in the counting. And so a very detailed review was done of that, which made some various recommendations. And so responding to those is leading to higher costs. So that's part of that. In terms of a 4-year term, we as a government haven't made a final decision as to whether to have a referendum, but it was important to put in the budget a potential cost of it around 25 million if we were to. And so that's a decision we have made. A lot of that cost would be just the mechanics of running the referendum, but also the necessary public information campaign that would precede a referendum, so that New Zealanders had a good handle on the arguments. And if I could succinctly put those arguments, Mr. Chairman, for the arguments for a 4-year term are broadly around the fact that it gives governments a longer period to enact their program, and one of the downsides of 3-year terms and changes of government is that there's enormous chopping and changing. The arguments against, of course, is that the New Zealand Parliament has no upper house and no Supreme Court striking down legislation, and so the one check we really have is to the ability to throw governments out, and we should be able to do that on a more regular basis. So that's the argument for 3 years.
Thank you very much for that. Right.
So on the first part around the Electoral Commission, what expectations have you made clear to them around their system performance and delivery?
I've appointed a new chair, the Honourable Simon Moore, and very much the focus is on ensuring that the integrity of the system is improved, and New Zealand's public's trust in the system is improved. And then thirdly, the timeliness of the voters improved. And those are the sorts of the measures that we're looking at.
And then on the 4-year term referendum, the 25 million that you've provided for operational costs of the potential referendum, could the referendum be held at a later date in the future? And additionally, would you expect potentially local government terms to also change in the future as well?
In theory, it could be at a different time. That budget proposal would be if it was to occur at the time of the next general election. And that is, I think, the general proposition. In terms, and if there was to be a referendum and it was to pass, then the next general election would be in 2030, is that right? I think, and then there would be a logical discussion to be had about whether or not to extend that to local government, but that's not something that is being proposed in this particular bill.
Right, any other questions on that electoral reform? Okay, I'm going to go to Ms Anderson.
Thank you. This might be one for officials more than you, Minister. Sorry, don't knock so. I've been trying really hard to get some clear data on family violence trends in New Zealand. We've gone through police, through Te Puna Aonui, and also Ministry of Justice. When we were in government, it was able to clearly track where family violence was heading in New Zealand. It went up quite significantly as reporting and continued to increase. And in fact, when we were in government, the increase in violent crime, 70% of that increase of violent crime was family violence because of increased reporting. Under your watch, I cannot get a clear answer what is happening with family violence in New Zealand. So I would really like to be pointed in the right direction.
Very happy to do that.
And my concern is, I'll add two in one. The second leg to my question is, my concern is when you have set yourself a target for reducing victims of violent crime, when we know 70% of that increase was family violence, at the same time as police stepping back from attending family violence, I am concerned that you are fulfilling your own targets by not reporting accurately on family violence in New Zealand.
Well, look, the primary answer is that the primary measure that we're using for our target is the Crime and Victim Survey, which is independent of the government. It absolutely includes family violence and family sexual violence. So unless you're questioning the integrity of that survey, which I'm sure you won't be, then that's it. And we won't achieve our target if we don't deal effectively with family violence, which, as you say, is a very significant part of the mix. So that's core to our whole foundations. But in terms of the actual sort of figures, I've seen some improvements, but I'm not quite sure.
Look, I don't have the specific figures, but we may be able to deal with it in the next session with Minister Chaw when she's here. As the Minister says, we are using the same stats that we were using, Crime and Victim Survey. There is also police reporting, which will be on the specific call-outs that they have. There is a discussion around how often police are responding with the new system of triaging, which it would be for police to answer that, but information I've actually seen just in the last few days suggests they're actually attending more sites because of more events because of the way that's been triaged. So, I mean, we'd be able to explore that a little bit more
I think
detail.
We're a bit premature on that. Have you got anything that relates to the estimates on this?
There's also there's the outcomes report, which the format which was established previously, and that'll be coming out.
I'll go to Mr. Nakle. You got a stuff on it?
No one asked about the infrastructure.
We're going to Ms. Nakle.
Oh, okay. So, all right. Okay, cool. Thank you, Mr. Chair. Minister, I note that, and Mr. Kibblewhite, I note that Vote Justice includes 52 million for the provision of justice policy advice and sector leadership. And as we've heard throughout the course of today and yesterday, there's a strong victim-centric approach by Minister Goldsmith in this administration. We've prioritised law and order. We've been very busy in that regard, and in the pursuit of this. And I know from my door knocking just over the weekend, as I said yesterday, one person said to me, "Thank you so much for making us feel safe," and others said other things. What I'd like to ask, and maybe perhaps it's for Mr. Kibblewhite, how does this government's and indeed this minister's work program come, especially with the victim-centric approach and how busy we've been, compare vis-a-vis the previous government's work program?
No, I'm not interested in what
Okay,
new
then if that's the
developments
case,
is the question. What new developments have you done? Well, proposing in the budget estimates.
Can I just make the general observation that we have, there's about 39 million bucks a year spent on policy development. And that's actually increased a little bit, has it? Over the last few years, and that's primarily because we've got an extremely busy justice agenda. And I just do, I'm not sure if I have already, but I do want to acknowledge the hard work of the staff. But I'm conscious I've got 4 more minutes, and I don't want to deprive Mr.
Right. Have you got one more
Webb
question?
of a final question.
No, that's it. If
All right,
there's another
cool.
one.
We've got
Thank you.
probably the last one from
Victim-centric.
Mr. Webb.
So I've got your
Doctor.
letter to the north side and what have you. And-
Is this to deal with the estimates, eh?
Yeah, no.
Yeah,
It
cool.
was seen on budget day for good reason. And it notes that you're not going to fund new courthouses in Rotorua and Waitakere.
Yes.
And they're pretty grim, those courthouses, leaking roofs. Apparently you have to use single ply toilet paper at Waitakere because of the sewage system if you're visiting. But you also say we're continuing to work on options to deliver these new courthouses. So are you going to get someone else to build these courthouses and lease them? Is that what you're exploring? Is this a PPP?
No, look, ultimately, how we deliver them is, there's a range of options. But the fundamental question is the budget to do it. And it's a question of timing and when that will be available. I appreciate the member was part of a government that previously had a much more expansive view on government debt and government spending. We are obviously in a more constrained environment given the broader pressures that we've had on that. And so we want to do that. We want to do those courthouses, but we haven't been able to fund that in this budget. And we hope to fund it as soon as possible. But I do want to make the point that notwithstanding the fact that we're not right here, right now, doing Waitakere and Rotorua, already right here, right now, the justice sector is doing more work on courts than has been done in the last 3 decades.
And we have purchased land for both those sites. So the land has been purchased in Waitakere and in Rotorua for those sites.
Right. And just in terms of Waitakere, that's a leased building.
Yeah.
Why is it in such poor condition with the roof leaking and what have you, given you've got a landlord who you're paying rent to?
Well, we have.
That's a very good question.
We are. Calvin may want to answer something. We are actively working.
Chopping block.
We're actively working with the
Well,
landlord.
the
They have made
media
a range
reports
of.
on this go
Okay, well,
They've
we'll
made
hear
a
from
range
the
of
man
repairs.
responsible.
Okay.
Is there anything you want to add to the Waitakere situation?
Sorry, could you just introduce yourself again? Sorry, I know you came up early.
Calvin Watson, Deputy Secretary Corporate Services.
Is there anything to add to the Waitakere?
No, I mean, ultimately, we're working with the landlord. Part of the reason that we're looking to build a new courthouse is that we're then in control of the facility and being able to manage that over many years, manage the maintenance.
Are you in dispute with the landlord? Because why are you not litigating if it's been leaking for years?
Repairs have been undertaken. It's not a very good building. It's the fundamental problem.
Right. I'll give you the very last one, Lawrence.
Thank you. I do find it, I can't speak for previous government because I'm a first-time MP, but I can only speak to the experience of this term where I find that it's interesting that you mentioned that there's a lack of budget for new courthouses when the government is able to find $12 billion for defense, but not a fraction, a very small fraction, 2% in fact, to build new courthouses. How do you rationalize that?
Well, every government has to make judgments about where to put the resources, and we're mindful of the fact that we're living in no longer living in a benign defence environment, and so the government, in its wisdom, has decided that we need to invest more in that capacity. As we've decided also that we need to invest a significantly larger new amount in health in education, and a whole bunch of areas. And so that's the joy of piecing together a budget, is weighing up all those things one against the other. But the government is very, very focused in ensuring that we make progress towards our broad target in the justice space, which is to reduce the number of victims of crime. And the good news is we're making good progress.
On that wonderful note, I think we'll finish it, and thank the Minister and also for everyone from the Ministry of Justice for attending today.
Thank you very much.
Right, we'll get Minister Chua. There's a folder or something. Members, I'll remind you, it's all about the S.
Mr. Chair, just while we're waiting, the act camera guy just wants to come in and take some pictures during carrying this. Is that okay? Yeah.
Only another 3 days. Right.
We'll see whether I do it or not.
Trying to help you prep.
Yeah.
Dodging.
Ah,
I've got one
Back
answer
again.
a question.
You want to start?
Right.
Oh, good. You're back. I know, Mr. Kibblewhite.
That's my briefcase.
oh, did you?
That's my briefcase.
Oh.
You're the act guy, eh?
I don't think we did.
I don't know. Right. Well, first of all, I'd just like to acknowledge the Minister for coming this afternoon. We've got 45 minutes. Also, all the other officials who are joining the Minister. Minister, you may be aware under the new standing orders that you can do an introduction for 3 or 4 minutes, and then we'll get straight into questioning. Thank you.
Thank you. So yeah, I appreciate the opportunity to talk about the important work that this portfolio is about, which is prevention of family violence and sexual violence. There are significant problems within our communities. That's why this portfolio had to be created in the first place. So as the Minister for Prevention of Family and Sexual Violence, it's my responsibility to lead improvements to the family violence and sexual violence system. And that involves overseeing and coordinating cross-government work streams, policies and investments to deliver on the Te Aotearoa strategy plan. I work alongside ministers whose portfolios span different aspects of the system. I am responsible for one appropriation within justice, which is used to fund the Te Puna Aonui business unit. The business unit supports the interdepartmental executive board, and that board coordinates the all-of-government approach to prevention, response and elimination of family violence and sexual violence. The funding in this appropriation helps to deliver the national strategy through action plans, collating data and insights, and use that to improve the system and create and implement a workforce capacity frameworks and enhance and support integrated community responses. Members may have noted an adjustment of $1.4 million in our appropriation for 25 to 26. In the previous year, a fiscally neutral transfer was made to cover overheads related to a shared service agreement with Justice. That was to enable the business case for Project Whetū. This transfer was removed for the next financial year and will not impact on Te Puna Aonui operations. So I'll just leave it at that because I know there'll be questions, but I'll say the goal of this appropriation is simple. It's around breaking the cycle of violence, and it's around requiring effective collaboration so victim survivors can receive the right support at the right time, and it's more accessible and safe for them to do so.
Well, thank you for that introduction. We're going to start off with Ms. White.
Thank you. Minister, the number of victims of violent crime committed by family members increased 6.8% in the most recent quarterly report. Are you concerned that now is not the time for police to withdraw from some family harm fallouts?
I can't speak to police's specific
Yeah, I think we've
actions,
just got to
but
bring
what I
this back to
can,
the estimates, so.
but what I can say is that the police have been working on a pilot program when it comes to triaging their 111 calls to make sure that the right people are getting the right services. So from the information that I've been given through requests, because I was concerned around that space, was that this pilot shows that the framework pilot have shown 7.7% more family violence events have been coded as priority one for physical attendance by police. It's also noted that it indicated that since this pilot has started, police are attending a greater proportion of priority events more quickly, and less than 2% of all family harm events were labelled not for police and for the 105 line reporting. So they are showing up. They are attending events where people are in immediate danger, and they are constantly working on the way that they're triaging to make sure we have the right people in front of these events.
Yeah.
Thank you. So you're not suggesting that there isn't a 6.8% increase, and you know that there is a huge amount of the violence that spiked that is about family violence in the home, and you know 1 in 8 children killed in this country are killed in the home.
Yep.
I would like to know, in your revision of the plan that you're in charge of, where is your priority? Where are you going to stop that from happening?
I am responsible for Te Puna Anui. That is my vote. And Te Puna Anui has set a framework of priorities in the Te Aorere Kura Action Plan, which each ministry will be looking at to make sure that their priorities align with that action plan. And one of those priorities is around stopping violence. Another priority is around protecting children and young people. And part of that is looking at the workforce capacity and capability within each agency to make sure that we've got the right people in the right places.
So are you saying that your priority to fix that problem, because this is a national strategy for sexual and family violence, for people who are not familiar with the term, are you saying that you're going to fix that by just looking at that workforce issue?
Absolutely not. It's a real complex issue. I'm saying that's part of what we're focusing on. We have taken the first action plan and we have created the new action plan that has just been launched, which has less focus areas. It has 7 focus areas for the government and NGOs and community organisations to focus on, where we think will make the biggest difference and the biggest impact within our communities. And those are just part of what the solutions are. Workforce capacity and capability is a big issue across the sector, not just in New Zealand, but worldwide. And we have to face the realities that we need to get more people training in this space, making sure that more people are trained in trauma-informed practice, so that when we are showing up to events of family violence, that we're dealing with them in the appropriate way.
So just to help the member.
Could I just make a comment on the numbers as well, so that I'm not 100% sure which numbers you're looking at. They did go up from when the October in, I think, 23, when the target was first set. They climbed quite a bit up after that. They've now dropped down quite a lot. So I think the numbers that we have, I'm not sure if they're the same one, is that October 23, there were about 44,500 odd victims of family violence. That did increase in the quarters subsequent to that, and is now come down. So the most recent one as of February this year was at 47,000. So slightly higher, but a peak that's kind of gone in that sort of direction. I wasn't sure if those were the numbers you were referring to.
Can I ask a follow-up?
Yeah, you can, but to give the member a bit of assistance, I think the question should be phrased along within the 20 million budget. What are you doing to do X, Y, Z, as opposed to more generalist? I just want to make sure that members know this is about the estimates.
Right. Can I just?
You carry on.
About the estimates. I won't ask my question. I'll follow up later in writing. But what I will ask is, in the last estimates hearing, you told the committee that we would expect gaps that could have been funded in the budget 24, where there was no bid made, would be funded in the budget 2025. How were these funded in budget 2025? Because I can see no new money spent.
Yeah, I'll forward that on to Emma, who can talk to those issues.
Well, it's you who've said.
No. Let's hear from Emma, is it?
Hello, everyone. I'm Emma Powell. I'm the Chief Executive of Te Puna Aonui.
Good.
So you're right in that there was no invitation for budget bids for this time round. We are undertaking quite a detailed baseline review of all of the funding across the portfolio to understand effectiveness, gaps, access, utility, etc., with a plan to have some decisions made this year for better utilisation of that funding where that's required. At this stage, in terms of the introduction and building momentum behind our second action plan, we don't believe that in order to do the things we have to do right in front of us, that we need new money for that at this stage, but we will be looking toward reprioritising next year and into the future years to help to really support the work, particularly in our multi-agency responses on the ground.
Have you finished? No, we're going, that's a new question. Have you got any more?
I've got this question. You've got, you've talked about identifying those gaps. What are those gaps as you see them?
So in terms of gaps that were discussed last year, a lot of that was identified through a gaps report that was undertaken by MSD, but largely informing all of our agencies. There were several big areas. The top one was actually workforce capacity and capability, and that is focus area number 4 in our new action plan. It's a continuation of work that we've already started, but under that we're proposing to train up to 10,000 frontline statutory workers in the next 2 years against our workforce capability frameworks, as an example. Other areas of gap are around sexual violence responses. That's one of our key focus areas in the action plan. There's work underway, for example, with MSD and ACC to create what they're calling sort of one front door, a better access route for survivors of sexual violence to come forward. So there are several ways in which we've picked up the gaps from that report and pulled them into the focus areas of the action plan. Let me be clear, though, that in terms of the funding following those gaps and being able to really support a system that can prevent and respond to family violence, we will need more work to be done to look at what, where that funding needs to go. And again, as I say, how effective it is. We are working closely with the Social Investment Agency and the new proposals that have come out through social investment to start to use some of those tools as well to look at better contracting, commissioning and social outcomes for family violence.
I think I'll leave it there.
Okay, now I've got a couple of subs, Mr. Stevenson.
Yeah, mine's really is a sup on this, because obviously we've heard about the new action plan or the second action plan. So really, Minister and your team, is it like to see quite a lot of a leadership role, and that's what you're going to be now? You've got the new action plan. I just want to hear a bit more about what is your role leading other agencies in government, and how are you working with them? Because obviously, as we've heard, it's a very modest appropriation. You actually don't have all the levers or all the answers. So I'm very keen to understand in the next year with this money, how are you actually going to bring this action plan to light and work with others? And you've talked to some of the agencies, but I want to hear a bit more detail about that. And what is the role?
So Te Puna Aonui basically takes the lead and sets the direction through the action plan of where to focus and what priority areas we need to focus collaboratively across government. And they work with the IEB board, which is all the top members of each agency who are accountable for making arrangements to improve in that space. And that they have all agreed to the new strategic intentions set out to align their priorities across government agencies to the Te Ao Rerikura Action Plan. In March, they adopted the new operating procedures that formalised their core duties and the expectations on the IEB agencies, which is all the agencies that have a role to play in this space. The procedures are set out escalation protocols if they breach those duties, and their core duties will include the need to formally consult and share information with other IEB members where any decision or changes will be made that will have a potential impact in the family violence, sexual violence system. They'll take on a view, an agency-wide view rather than a siloed view and just an agency view, and they'll deliver to the second action program. And they also have to give assurance around progress within each agency and what they're doing in this space.
And just a quick, and so will Te Pānui be actually measuring what the other agencies are doing against the action plan and steps they're taking?
So last year we adopted a common framework of outcome measurement for the whole through our aspiration toward our strategy. So that's one way that we're measuring progress. And each year we'll be putting out a report against those measures, which all agencies are contributing to. Our second action plan has a number of performance indicators and other measures such as milestone delivery. So we're tracking that, reporting it through to the board and ministers periodically. We obviously have our annual cycles of accountability where we're providing that information through. I think that there is obviously there's an accountability that rests with individual agencies and ministers to make calls and decisions individually, but we are looking to operate as a system so that we are looking to try and do things as collectively as we can. So we understand when one does one thing, what those ripple effects might be, and that's what the minister's alluding to in some of those strengthened duties and how we do that.
Okay,
Can I try and
one
make
more.
that maybe just a little,
go,
more practical on that? Because, I mean, when the rubber hits the road, you've actually got to get agencies working together when their inclination is often just to do their own thing. One of the places that is most sharply felt is actually in the local area where you are responding. So one of the emphases of the action plan is to act locally in a much more joined up, coordinated, multi-agency way. Minister talked about Project Whetū. That's work we're doing collectively to build an information system and an operating model that will actually enable a much more collective response on the ground. And as we move that forward, I think you'll be able to see quite measurable impacts in terms of how much harm is occurring in a place, and looking at the collective role of the agencies to deliver something on that front.
Most useful. Now I'm going to have one more sub, and then I'm going to go to a new area.
Okay. It's around the leadership and the multi-agency approach you've got there, and you talk about services on the ground. Recently, a number of services on the ground, particularly counselling services, have had significant funding cuts, and it's been ostensibly on the basis of overlapping services, particularly between ACC and MSD. Now, there's a strong argument to say that these are doing entirely different things, that the ACC claims in counselling is doing one thing, whereas the long-term counselling that's offered through MSD is an entirely different thing. So I'd just really like you to address what's going on there and why there have been cuts in this estimates for these counselling services.
Well, there haven't been any cuts for those services within the vote that we're speaking to today. So if you have questions around ACC funding or MSD funding, they come from a different
I have a question about, and I'm not going to let you off the hook here. I have a question about the coordination between agencies, which is your core role, and the fact that the agencies seem to have concluded that simply because they're both offering counselling services, one of them can cut them. So I'm asking you, in terms of your role of coordination and oversight, what do you know about this? What's going on?
Yeah, so the direction and the expectation is that these agencies no longer silo, because there is duplication across agencies. And when they weren't speaking to each other, we did have duplication. So if ACC and MSD have had a conversation and they've decided that they're going to make some funding changes, and they've done that through speaking to each other and coordinating that, and there's duplication, then I don't see a problem with that.
Well, the difficulty is that ACC therapy is about the immediate trauma.
Yeah, I can't speak to ACC decisions.
And MSD therapy is about long-term outcomes.
Okay, but I think we'll have to pick that up.
So we'll put this in writing, but it's pretty disappointing.
Did you have someone else who wanted to talk on this? No.
I can.
Just briefly, yeah.
So we had $1.7 million.
Sorry, can you just introduce yourself?
We won't hear you properly.
Just introduce yourself, thanks.
Okay, so I'm Mark Henderson. I'm the General Manager of Safe Strong Families at MSD. So we had 1.7 million of very historical services of a mix of stuff that our crisis providers had. We've ended that in 6 months' time so that we can, because we've got a baseline review going on, and at that point in time, we'll relook at where investment needs to go in the system as part of the whole baseline review.
Did you consult with providers?
I think the last question, right? This is it.
No, that's a really important one, right? Did you consult with the people on the ground?
Talk to the providers all the time.
Did you consult with providers about this decision?
At the end, no, the decision was made.
No. Okay.
I'm not sure what decision you're referring to be honest.
Yeah.
$1.7 million.
I mean, there are multiple decisions being made here. Some may be made because it's time-limited funding, and that it was.
This is
coming to
not
its
within your
natural
budget,
end,
though.
but it's not under my vote, no.
Yeah, that's the issue. We've again got members. I'll draw you back. No, but you're trying to draw a long bow. Right now, Ms. Davidson, new line of questioning.
Thank you, Mr. Bailey. I just firstly want to acknowledge that I know the Minister cares deeply about this work and wants to see us preventing and eliminating violence. Mr. Bailey, to your point, the Minister absolutely, while she doesn't have a direct responsibility for the votes, the whole point of the ministerial role is to have an overview across what is happening in other departments. So I forewarn that I am going to pick up her overview role. And so noting that the Minister absolutely cares about this, wants to see outcomes, but also noting that I think for 2 years in a row now, we haven't seen an invitation for bids from this Minister. We have seen ACC make a decision to pause the rollout of its prevention program. We have seen the Minister for ACC float the idea of cutting entitlement to victims of sexual violence without conversation. We've seen MSD notify community organisations of cut to funding streams. We've seen Te Pūkotaitanga wind up, which leaves that ability for an enduring authentic relationship at a rangatira level. With all of that happening, I ask the Minister authentically, does this government still prioritise te aurere kura and eliminating violence?
Oh, absolutely. I'm out and about in the community constantly talking to this sector about what's working and what's not working. But what wasn't working was what we were currently doing and working in silos as government agencies, causing many areas where honestly there was duplication of services. We didn't have a good understanding of what each agency was providing in services, which is what the social investment agency approach is really about. It's about making sure that we're getting the right services in the right place and coordinating across government to make sure we've got those services in the correct places. We're absolutely dedicated to this piece of work. And the reason that when you talk about asking for a new bid, there's no point asking for a new bid if the agency has just said in the previous answer that that wasn't necessary to complete the role that they needed to complete. Now, if there is a need for extra funding going forward, then that will be asked for. But I have been assured that Te Puna Anui can complete their role with the money that they currently have, and there was no need for an extra bid.
Supplementary, thank you for picking up, I guess, the evidence sort of angle on what's working, which I think is what you're starting to allude to. Can the committee be assured that the Minister is really leaning into best practice, what is being seen and felt in terms of impact and outcomes in community, including it could be small and local organisations doing fantastic work? What is the evidence that the Minister is relying on? Because if the Minister's saying on one hand there are gaps, on the other hand, do we not have already some solid, credible evidence about what is working, and why can we not bid and support more resource and support for those very initiatives?
Yeah, so it'll be up to the individual agency who's responsible for funding that particular, whichever particular NGO you're speaking to. But what I do encourage from the position of advocation in my space is that if we do see that something is working really, really well, that we make sure we are funding and resourcing that space to the best that we could possibly resource that. And we have found areas where we have agencies on the ground that are making a massive difference, are running on the smell of an oily rag, if you want to put it that way, that should be funded and should be resourced a lot better than they actually are. And then we've found others where they may not necessarily be producing the outcomes we would have liked. So we will move that funding around to make sure that funding is producing the best outcomes.
And one more sup, please. Thank you, Mr. Bailey. And I mentioned at the start the winding down of Te Pūko Taitanga, and I'll see you there next week, to acknowledge them. But the Auditor General had a particular concern that the TDT relationship was not adequately factored into decision-making or engagement with Māori providers. And part of that, I believe the Te Aurere Kura itself mentioned and initiated Te Pūko Tahitanga partly in response and specifically to note at the rangatira level of engagement. So what is the Minister's response to that Auditor General's concern about upholding the TDT relationship in this work?
Oh, look, I actually think that's really, really important. But a large amount of funding was put aside for this advisory group to put forward what was working in their communities, what wasn't working in their communities, and where their strengths and weaknesses were. They have done that work. They have completed an evaluation, including a Te Ao Māori strategy to support whānau affected by violence. They've also done the Litany of Sound Literature Review, which was actually really quite a great resource if anyone's looking for a great resource in that space. They also did a Te Ao Māori theory of change and advice on data collection, which was so important. And they had a creation of around kaimahi Māori to share insights around mātauranga. They have done an amazing job, but now is our time to deliver. So that's come to its natural end. We're not renewing that to continue. The funding that was going towards that advisory board will continue to be putting into the Te Ao Māori space and delivering on what that board actually produced and wants us to deliver on. So that will continue. We'll also stand up a new advisory board which can actually advise me on multiple areas in this space, not just a Te Ao Māori view. That board was very limited in how they could advise me. They could only advise on Te Ao Māori issues. I was needing a wider range of advice from across the sector. So the decision was made to put that money towards delivering on what that advisory group had put forward and to create a new advisory group that would enable me to have a wider scope to be able to be advised on.
Thank you. And just supporting what the Minister is saying about the Litany of Sound, the Te Ao Māori approaches and evidence, and Ms. Powell, you did mention, will that work and research and evidence be put over and to the Social Investment Agency so that they too are taking accord of the right things happening in your space as well?
Yeah, so the advice that's been brought forward to me, I most definitely do put that advice as advocacy into the work that's done across the IAB board. I have set my expectation to the Te Puna Anui Agency that this work be incorporated into the work stream going forward. It is really, really important that when we are collecting this advice, it's not just going to sit on a shelf and grow cobwebs, that we actually deliver on it.
Thank you.
Okay, I've got a couple of subs. First one, Ms. Viol.
Great. We've moved a little bit away, but I promised it was a sub in terms of the original question. There have been some of the community organisations that have had their funding slashed, and there's been scathing criticism from the Auditor General about that. And while you shake your head that that's not your portfolio, I'm still speaking to the fact that as a minister, your job is to be over all of those impacts. So you've seen that stuff happening with something like the North Shore Women's Centre, where in fact you were critical of what they were doing and said other services would be provided.
Mhm.
Do you look at that review and take lessons from it in your own portfolio about where the priorities should be? Because those are the community services that stand between us and people dying.
Look,
But we've actually had people say that from those organisations, that people will die as a result of the fact that they've had their funding cut. What do you say to them, and have you learned those lessons? I know Aotearoa Tamariki's in another basket, but you're the minister responsible for the entire strategy.
Yep. Okay. So what I would say to you is if you would like to ask specific questions around contracts with that vote, there's an opportunity for you to do so tomorrow with the Oranga Tamariki vote. But what I would say is there is a direction to make sure that we're getting contracting right and that there is not duplication, that there isn't underutilisation, and that we're making sure that the money is getting best value within our communities for outcomes. So some decisions where agencies will lose their funding, that's unavoidable, but there'll be other agencies that will get increased funding. So we need to make sure that when you're speaking about saying that there've been cuts, there's a reprioritisation of the way we're spending our money. We are actually making sure that we're getting outcomes for the money that we're spending. And that is my expectation.
Mr. Ferris.
Tēnā koe, Minita. Look, just a quick one. How much of your $20.6 million portfolio goes directly to Te Aorere Kura, and how do you measure its success?
Do you want me to answer that? Kia ora. In terms of the appropriation, we have a mix. So we have some operational spend. It's about 7.5 million of the 20. The remainder goes towards specific budget lines. So the ministers talked about Crown Motley relationship, but beyond relationship into outcomes. So about 4.2 goes toward that. We have about $1 million going into outcomes and insights. And so we've talked a bit already about the importance of data and data collection. And so that's helping us to do that. We have significant amount, about 4.6 going into integrated community responses. And that's when we're talking about that multi-agency response on the ground. And some other funding that goes to help support workforce capability development. So as a unit, yes, we're there to work across the system and to help coordinate the agencies, but we do some delivery where we see it's going to help to enable the system to be better.
And your measures?
So I mentioned before, we're measuring our pursuit or meeting the strategy through our outcome and measurement framework that has a range of measures from wellbeing outcomes through to prevalence and incidents, a whole range of outcomes against strategy shifts. We also have some outcome measures, obviously within our appropriation around ministerial satisfaction. We have measures around delivery, making sure that we are managing, monitoring things, etc. So there's a range of ways in which we're measuring our success. The last way is obviously targets for the government are a priority. Target 4, reduction of violent crime and reduction of victims. We contribute to that. And so a portion of that victim target is about 6,000 who are impacted by family violence. And so that's what we are looking to try and impact.
Yeah, Kapa, good to hear you've got targets. Do you have an idea of how much, the degree of funding you put into kaupapa Māori solutions?
So we, in our appropriation, are putting funding into some iwi community partnerships for multi-agency responses. Now, they may utilise kaupapa Māori approaches within those, but we're not necessarily funding direct service provision. We're looking to help enable agencies to come together. So a good example is funding for Ngāti Kahanunu to support their multi-agency, their participation and coordination of response in the Hawke's Bay. We are funding into Manaaki Tairāwhiti, which is an iwi partnership with community, and helping them, in fact, this year really start to support more of an iwi hub approach to one whānau, multiple issues. So yes, family violence is one of those, but there'll be lots of ways or lots of things to address for whānau within that. So we're looking to sort of invest into things that are already working and to try and really to help to scale and support, particularly from a family violence perspective. In terms of the whole portfolio, there are supports and funding that does go into kaupapa Māori services, for example, in MSD around sexual violence. There is a portion of the ACC prevention spend that goes towards kaupapa Māori, but I would have to gather all of that up and I could provide you that answer at a later
Ms.
date.
Davidson, you've got one last up on this.
Thank you so much. Go Manaki Tairāwhiti and Kohumanu. It was the outcomes measurement framework. Really hope that the Social Investment Agency are going to pick that up because that's what they're looking for. So is that the plan?
Yeah, so in our conversations, now no final decisions have been taken, but we are looking to utilise, you would have heard reference to Te Aurere Kura, also reference to our outcome and measurement framework. We have outcomes for our action plan that will be really critical to the future of social investment, reducing violence, reducing re-victimisation, reoffending, importantly, children growing up in homes with family violence as well. So those are what's in our sights for social investment.
I would hope there's a really close link between.
Absolutely. And then in terms of the Toyota framework that Pukotahitanga have funded and developed, they've been, and with our support, discussing with the Social Investment Agency, how do you pick up those outcomes within this frame as well? So we are working into those areas.
And some of the milestones that Puna Anui have delivered upon will help with that work. So we've published the risk and safety practice framework, which can be used in making some of those decisions. We've also completed a local systems improvement plan in Rotorua and Christchurch, and soon to be completed in Auckland City Centre. And that will identify actions needed for each location to strengthen the response in those areas. We're accelerating specialist outreach in Auckland City Centre, Rotorua, so victims and their whānau can receive intensive specialised support. So hopefully that helps in other agencies linking into that work and the data that we've started to collect to be able to make the right decisions about where to put those services.
The risk and safety practice that
Right,
is
that's
the
fine.
responses one.
That's fine.
Oh, it was just, is the risk and safety practice framework the safe responses stuff?
It's taking a lot of the capabilities across the family violence frameworks and targeting them at risk.
The workforce
managing
frameworks.
risk.
Yeah.
Okay,
thank
I
you.
want to go to Ms. Nagley and then I'm coming back to Ms. White.
Yeah, this is just a supplementary, but also relates to something mentioned earlier. Hi, Minister and team. Emma, earlier we were talking about the GAPS report in response to a question about how we tangibly, or rather measuring outcomes. And you did refer to the GAPS report about making us know basically what's the gaps. And you said that alarmingly the biggest gap was with respect to workers. And you said that there's training underway, and from what I understood, I think some upskilling as well in current staff. But I was really curious to know, can you please give us some real life kind of practical examples of where the gaps are in the existing staff, and just things that I presume were alarming as well to realise that these gaps. And so yes, just curious about some practical, what do these gaps look like in the workforce?
Yeah, for sure. So
they need upskilling.
One of the Family Violence Death Review Committee reports talked about a duty to care, not a duty of care. And so of course we have a duty of care, but for our workforces, and I'm not just talking about specialist NGOs, I'm talking about the people in the GP office, our teachers, our educators, people who are coming into contact with New Zealanders every single day.
Staff in the courts.
Yes, in the courts. And there's been a lot of training happening in the court system. And again, it's all of the staff. It's not just particular groups. So when we think about the capability, it ranges from what we'd call essential level training. Everybody needs to know how to recognise, respond and refer, all the way through to very specialist providers who are, running dedicated NGOs, etc. And so quite often family violence can not be picked up. Wrong questions can be asked and people can perhaps want to come forward but have a poor experience and then sort of retreat again and think, no, I'm not safe to come forward and to seek that help. So one of our biggest challenges is that engagement, and it's making sure when that person is coming forward, at times not for deliberately asking for help. Sometimes it's in seeking health services and a range of other things. So we need our frontline to be vigilant and knowledgeable and able to respond well.
So some practical progress that we've made in that area. So by January 2025, the Ministry of Justice delivered foundational training to 800 members of its court-related workforce. So the ministry expects that to reach up to 500 people a year. Also, police recruits now get 2 weeks of family violence training matched to entry-level requirements. So over 550 recruits received training in 2024, and over 850 are expected to receive that training by the end of 2025. And as of March 2025, over 4,700 corrections staff have received essential level family violence training. So it's making sure that these people understand how to deal with these situations in a trauma-informed way, so that we're actually making a difference and not actually causing more harm in the way that we're practicing.
That's really
And
good
supplementary, if I may, please. Thank you, Minister and Emma. So I'm presuming it's an array of professionals that are conducting this training. Like, are we talking about social workers, psychologists, police officers, etc.?
Yeah, and it's not just even in that space. So when I am out in the communities talking specifically to rural communities and probably in Māori-led organisations, we have a lot of people within communities that are very capable of working with families and are trusted in their communities to work with those families, but they don't have that piece of paper. So it's finding a way to upskill those who have the skills but don't have the piece of paper to come in and work in their community where they're respected and enable them to do that. So that's part of where we're aiming to as well, because we can't take people out of their communities, bring them to big cities, expect them to leave their communities to do some of this training and then to go back to their community. And often we find they don't go back to their community. So it's having a look at how we can bring the training into the areas that do have a lack of services and upskill within that community.
Very good. Good
Awesome,
question.
thank you.
Right, Ms.
I'm
White.
going to try and put two questions in one because of the time. The gaps in the plan as it is now. What I'm hearing is that education is a huge part of it. You've talked about educating the workforce, but educating the public about what's acceptable and what's dangerous is a big piece that seems to be missing. So does child abuse, because the child strategy in Australia is a separate strategy, and it seems very successful in comparison to us. I want to know, where is the budget going in those two areas?
So my understanding is that there's a plan in place now across agencies to put together an education program around some of the spaces that you're speaking to, but I'll get Emma to speak to the budget side of that.
So in terms of the action plan that we have right now, in terms of campaigns, we obviously under the prevention priority there, MSD are funding into Loves Better, It's Not Okay, Pacifica Proud, Etu Whānau, which are all multimodal sort of prevention campaigns. And there is, through our baseline review, an opportunity to say, how effective is that? What else do we need to do there? So I don't think that future education campaigns are off the table. It's just not something that we have, we're prioritising right now in terms of active activity, but we will be looking at that into the future. In terms of budget, as I say, that would come through our baseline review and future decisions about where to reprioritise funding toward. I think that's about all I can say. And for children, yeah, so there is clearly, there are a couple of things. So one, in our plan, we have a dedicated focus on children, and more importantly, within our work around multi-agency responses, we know, and some of the barriers we've identified, is that children can become very invisible in family violence situations. And so the response happens, and quite often the needs of children are not being identified and met. So as we start to redesign what multi-agency responses look like, children are very front and centre as part of that design. In terms of other places where children are being picked up under the Child and Youth Strategy, which is sitting more within MSD, there is a key area of that of reducing child abuse. And so there are significant elements of prevention for child abuse sitting within that strategy.
One more, yep, last one.
So I've got to pick one. It's hard, but in terms of education, you've talked about some of those things, that some of the new alarming things that are going on are linked to non-disclosure. So people don't even know that this counts as rape. They don't know it's abuse. What are you doing about that very emerging issue, particularly given what I hear from people like the Lighthouse about the kind of digital playing that's going on that's just so dangerous and people don't know?
Yeah, absolutely. Recently, a number of stakeholders came together to understand the last year of research and evidence around what is happening, particularly in that digital landscape. And what's happening digitally is also happening in real life. So there are things that are crossing boundaries. It's a scary situation and there's a lot to be gripped up to understand what to do around that. We are starting to have a good look at that whole landscape to understand where might Te Puna Aonui put its focus and attention on that, particularly as we look forward into new priority areas under our action plan. We need to be able to pivot or kind of adapt to these things that are coming our way, and we do need to be across that. In terms of some of the education that does already exist, obviously working with DIA, NetSafe and other players to make sure that we are as aligned as we can be. So when education is happening, it's as informed and quality as it can be. There is a lot to do across the family and sexual violence portfolio, full stop. How we prioritise against a number of these issues is a challenge, and which is why we continue to look at where those needs are and what we might need to do to keep refreshing.
Okay, well, thank you very much. I just want to thank the Minister. I want to thank all the officials. Mr. Kibble-White's back in a few minutes. Members of the committee, we're getting a 5-minute break. We'll be back here at 4:20 for Associate Minister of Justice. Yeah, and it's food.
Thanks, Andrew. Thanks, Emma. Thank you, Minister.
Yeah, First of all, I'd just like to welcome the Minister. We've had Mr. Kibblewhite all afternoon, so welcome back for your third session, and to all the officials, thank you. As you probably know, Minister, under the new standing orders, about 3 or 4 minutes just to do some introductory comments, and then we'll open up for questions. Thank you.
Thank you, Mr. Chair. Good afternoon, everyone. Thank you for the opportunity to speak with you today. I'm here in my capacity as the Associate Minister of Justice. My designations include responsibility for firearms policy and law, the 3 strikes regime, and anti-money laundering. I will address matters relating to the court's portfolio separately because I'll be seeing you on Thursday this week. In firearms reform, at the heart of my work around firearms is a strong desire to keep the community safe. This has been reflected in my staunch advocacy for firearms safety and training in my career prior to entering Parliament. I volunteered to deliver firearms safety training in Wellington Central and went on to run the National Volunteer Programme. I was also contracted by New Zealand Police to deliver firearms safety training and administer the licensing test, as well as obtaining qualifications in firearms legislation, safety and training. One of my key priorities as Associate Minister of Justice is to make sure this country's firearm laws are coherent, consistent and contribute effectively to public safety. I've long supported fair and practical solutions that will help keep communities safe and back law-abiding licensed firearm owners. For the Arms Act, the current Arms Act came into effect in 1983 and has been amended several times over the last 40 years. It is clear that continued piecemeal amendments have failed to protect New Zealanders from firearms violence and have placed an unfair burden on law-abiding licensed firearm owners. At the start of the year, I sought the public's views on what works, what doesn't work, and what needs to change to inform the rewrite of the Arms Act. We received more than 8,400 submissions. These submissions are informing policy proposals that will inform the rewrite of the Act. We are committed to creating an enduring Arms Act that is fit for purpose, will increase public safety, simplify regulatory requirements, and improve compliance. For clubs and ranges, of interest to the committee, law changes to improve how shooting clubs and ranges are regulated will come into force on the 29th of June. Clubs and ranges have an important public safety role. They are places for people to learn how to use firearms safely, how to practice, and also compete. I've heard from many people involved in clubs and ranges who are frustrated by the regulatory requirements. The amendments to Part 6 of the Arms Act and the associated regulations maintain public safety requirements while simplifying the regulatory requirements on shooting clubs and ranges. These changes will provide immediate relief to club and range operators who have struggled to comply with the unnecessary extra regulatory burden that has been imposed on them. Most importantly, they mean New Zealanders will continue to be able to learn, practice and compete with firearms and do so in the environment of clubs and ranges where everybody's safety is paramount. Firearms prohibition orders. Changes to the FPO's regime took place on the 2nd of March, yet another important milestone in this government's ongoing commitment to reducing violent crime and restoring law and order. We've made 3 key improvements to the existing FPO regime. We're expanding the qualifying criteria for the court to make an FPO, giving police a new search power to monitor compliance with an FPO, and establishing a process which allows an FPO to be modified or removed. 3 strikes. The 3 strikes sentencing regime comes into effect today, the 17th of June, having received royal assent on the 17th of December. The reinstated law, which the previous government repealed in 2022, includes modifications to make the regime more workable than the original law. The reinstatement of this law is one of several parts of this government's commitment to prioritising victims over criminals and making criminals take greater responsibility for their actions. For AML CFT, anti-money laundering legislation has also been a focus for me. In my view, reform presents a great opportunity to enhance the strengths of our system, to address concerns with it and make changes for the better. The government has a comprehensive program to overhaul New Zealand's system for tackling money laundering and terrorist financing to make it more agile and responsive to industry and community needs and to take a more risk-based approach. Overall, the objectives of our legislative reform are to tackle organised crime and cut red tape by making the system more focused on actual risk. A risk-based AML CFT system will provide regulatory relief to lower risk businesses and save time and money for the New Zealanders who rely on them. Enable law enforcement to crack.
Just about, we need, doing anything on transnational, anything else, is that part of your as well?
Transnational organised crime is under the Minister for Customs, Casey Costello.
Okay, cool. I think that's enough introduction. Thank you, Minister. Right, I'll just remind members that this has got to be the estimates that relate to this.
She talked about stuff on.
Yeah, but your questions are in relation to estimates, right? Right, so we're going to start off, with Ms Anderson.
Thank you very much.
You should have asked me my permission to come in here, so you haven't?
Oh, sorry, I just thought it covered from before. Sorry, that was my mistake.
Right, okay.
He just popped out briefly, but sorry.
Right, let's start with you.
Thank you, Mr. Chair. Thank you, Minister, for your introduction. The review of the Firearms Registry has now been publicly released, and we all know about your agree to disagree position with that review, and on whether to do a second review or not. Could you please explain to the committee your plans for the future of the registry and outline what further policy work is going on with the future of the Firearms Registry?
Right, in relation to your estimates.
Yes, so the registry does not fall under my portfolio. It falls under the portfolio of New Zealand Police because the Firearms Safety Authority are in charge of the registry and they, of course, sit under New Zealand Police. So the views or the question that the member asked me is what do I propose to do? It doesn't matter what I propose to do. It's actually a government decision on what will happen in the future in regard to the registry, but it's not part of my portfolio. So,
okay, I'm going to allow a little bit of latitude, right, on this firearms, because you've mentioned in your introduction, but I'm going to do it so far, and then I'm going to say that's enough. So I'm going to allow the opposition to certainly ask some questions of government members, but I want you to respect this process. This is not about asking the minister your general views around everything. I'm going to allow some of the questions, but then we're going to stop it.
So these questions were asked, some of these were to the Minister of Police, and he referred them to you with having responsibility for firearms safety. So I would be interested to know whether you support in keeping A category firearms, the ordinary rifles and shotguns, in the registry.
So I've made it very clear that the view of the ACT Party is that we do not support the standard category firearms being registered currently now, especially because...
Okay. Sorry, Minister, can I ask you to talk in capacity as a minister, right? This is really important, right?
But I'm being asked for my view.
And I don't want you to ask personally. As Minister, please respond in terms of Minister.
Thank you, Mr. Chair. Nothing's changed in my response. I have made it quite clear in our cabinet paper where we stand, and nothing has changed in that response. However, what happens with the registry will not be dependent upon what I want. It'll be dependent upon what the government as a whole wants.
Right. Are you aware the overwhelming majority of firearms currently in the registry, around 90%, are those very firearms, the standard A category rifles and shotguns, that you want excluded?
Yes, and I'm not surprised, because when a person purchases or sells a firearm, generally, it will be an A category standard firearm because the number of endorsed firearms out there are quite low. In fact, if you think about, for example, a pistol endorsement, there's about 4,000 of them, as opposed to your standard, and all of them, of course, do have a standard category firearm. There's over 232,000. So it's obvious that the majority that will be on the system now will be A category.
You spoke about public safety in your opening remarks. What impact would it have on public safety and police's ability to trace diversion in the black market if the details of licence holders who owned all of those A category weapons were no longer recorded by law enforcement agencies?
Well, the fact
So
that.
we're into hypotheticals, aren't we? Because the government
Yeah.
hasn't come to a decision on this, has it?
No,
No, it hasn't, and nor is there any
No, but I'm not
financials
interested
attributed to
in
it.
minister's personal views. We're
said
here
as the
as
minister, she was
we're
going
here
to.
as a minister, right? So that does give a line of how to respond. Just reminding everyone, this is about estimates. I'm giving some tolerance because it wasn't covered with the Minister of Police. That's why I'm being lenient today. But I'd just say we're asking the minister what her view is in her ministerial capacity.
Yes.
I can reframe the
I
question if you
can,
like.
Okay, if you reframe, thank
So
you.
around 70% of firearms and standard rifles and shotguns or modified sawn-off versions of them are those A categories. How can the registry effectively work for public safety if police can't stop this flow of firearms from straw buyers to gangs and criminals and even extremists?
I think what the member would be alluding to, that straw buying would be the only way that criminals are getting firearms. And it's not. If it was easy enough to say that that is the way that they're getting their firearms, then we would be behind it. But the reality is that it's not. And when the member refers to 70% of firearms being seized, of being A category, there's also a significant amount of firearms of that 70% that do not have any clear registration numbers on them to be registered in the first place. What I would like to see is an increase of improvement in trust and confidence between the firearms community and the registry system. And when there's been 6 different breaches, not of the current registry, since 2019, but of firearm licensed owners' details, it's easy to see why the trust and confidence isn't there. Further to that, my understanding is that people have had issues with the registry. And I was hoping that we would be able to spend some time to improve aspects of the registry, including those items that are in its drop-down menu, for example, be able to get police to be able to work on it, to improve it to a standard where people do have confidence in it. At this stage, they don't. Many of the 38% that have entered the system have done so because they've been forced to. So when we start getting people entering the system because they want to, then I think we have a good change there, but we don't have it yet.
Just one more, if possible thing. The review of the Firearms Registry noted that police seized around 3,800 standard rifles and shotguns.
Can you repeat? I couldn't hear you.
The review of the Firearms Registry noted that police seized around 3,800 standard rifles and shotguns from offenders during the 2023-2024 financial year, the year the registry first started. Do you consider this demonstrates that the registry is working well?
No, I don't, because while they've seized a certain amount, they haven't told us how many actually came from licensed firearm owners and how many came from unlicensed owners. And this is the point, right? I mean, Thorpe even said that back in 1997. He was all keen for a registry, but he said, unless you get over 90% compliance, it's never going to work. And of course, we have a prolific amount of firearms out there by being owned and held by unlicensed people who are never going to enter that registry system. So I can see benefits, but I can also see that there are no benefits in some areas of it. So it's about improving a system before we start making people go into it. And that's the issue that I have with the registry.
Okay, I'm going to take a supplementary.
So a supplementary, we'll stay with firearms, but actually I want to talk to you, Minister, about something you are actually responsible for as Associate Minister for Justice and something that's actually under this appropriation, which is obviously the appropriation covers a lot of policy advice and support. You mentioned in your opening remarks about the rewriting of the Arms Act, which is actually something you're responsible for.
Yes.
Can you just tell me, do you think that in the coming years, we will see the money that's spent from the Ministry of Justice on helping you rewrite that Arms Act will actually be justified and will lead to better public safety?
Oh, look, I really do. I did not come into a position as a minister in charge of rewriting an entire act with a focus of making New Zealand less safe as a consequence of that. I think that what I can bring to this role with my experience and my background, especially in firearm safety and licensing, all my background in New Zealand representative sports representative roles as well, that I can bring an aspect to the rewrite That means that we get rid of some of the red tape and understand exactly what compliance needs to be made in order to contribute to good public safety outcomes. At the moment, it's almost like we have an act that's had everything thrown at it, but we have no outcomes. And in fact, we're seeing worse firearms crime over the last few years than we have before. This needs to change. And I think we can do this within the Arms Act. So my focus is not only on contributing to public safety, but also cutting that red tape and ensuring that there is compliance, because firearm owners know how to comply, can comply, and are eager to comply with the new laws.
Okay, good. Now we're going to go to a new primary.
Thanks,
Mr.
Chair.
Bates.
Thanks very much. You mentioned, Minister, in your opening remarks that the 3 strikes came into effect today.
Yes.
Could you elaborate on how these changes and any spend in the coming year will contribute to the government's target of a reduction of the number of victims of violent crime by 20,000?
Yes, well, the main thing that's going to happen with 3 strikes, of course, so it's implemented today, and it's a new regime. If I may take a moment, Mr. Chair, just to explain some of the background.
Yeah, good.
So under the old regime, we had 14,687 first strikes, 725 second, and 25 third strikes. The reason why I'm talking about what was in the previous regime is because as of today, some of those people under that regime will be moved over into the new regime. So as of today, there are 9,675, 61% of those that had a strike under the old regime are being moved over to the new regime. Of the 9,675, 9,350 are first warnings and 325 would be second or further warnings. And of course, from today, a person who commits one of the most serious violent or sexual offences from the 42 that they could be charged with could get a third strike. So we don't have any third strikers sitting in the new regime as of today, but they could be. In saying that, the 25 that were on a third strike are still serving their sentence. So what this means for money-wise and estimates-wise, of course, we will see people being locked up for longer if they commit one of these 42 most serious violent offences. But this helps us. It helps us to target our target 4, which is reducing the number of victims of crime by 20,000. And the way that we can do this is by making sure that those repetitive, really serious violent and sexual offenders are off the streets, that they're in prison, that they are serving time, that they've been warned about it, and then, of course, in the hope that we can get them rehabilitation before they come out as well. So there will be cost to having the 3 strikes regime. The government has seen that, and hence we have put more money into prisons, building prisons, but I believe also that there is some aspects towards rehabilitation that will be there as well. But from my perspective and what I'm doing, it's getting the regime up and running. There is some cost to the courts and the implementation of it on their part, but my understanding is that the way that this is going to work in the future, if somebody is charged with what becomes a strikeable offence, police will notify their defence that that's going to happen. And if somebody is wondering or worried about whether or not their strikes carry over, because there's a few that haven't, they will be able to go to the Ministry of Justice website and look up and see whether or not their strikes count.
Right, thank you. Another comment? Right, I've got one more.
Just a quick supplementary, maybe this is for Mr. Kilwell. For 3 strikes in the period going forward, which obviously this estimate covers, what more work does the Ministry of Justice have to do to implement this regime, or is that completed?
That's completed. The court's set up and ready to run with it as of today. We've put training in place, processes in place. It's incorporated in the prison projections as far as we understand it.
Thank you.
Okay, Mr. Scott Willis.
Thank you. Thank you, Minister. Budget 2025 indicates savings of approximately 18 million for increasing firearms regulatory fees. How has the Minister assessed whether those non-commercial firearm users, especially those in rural areas, who will face a bit of a barrier, could face a barrier to the cost, how has the minister assessed whether they might not inadvertently, whether this increase might not inadvertently increase the informal or more unregulated firearm ownership?
The most pertinent question we've had so far, right, to the estimates.
Yeah, that's not under my portfolio, that's under vote police, because police are the ones that have the 18 million. I don't have that, so I wasn't even, yeah. What I will say though, talking about fees,
Responsibility for firearms.
the actual fees that go to licensed firearm owners have not changed. They are, we will be looking at a fees regime as part of the Arms Act rewrite. I'm presuming that the 18 million that you're talking about, because it's under someone else's portfolio, I'm going to give you a presumption that that 18 million is actually for them to go about doing some of the changes that they are doing. As an example of that, the registry for the ammunition needed to occur. So that meant a forecasted budget, I think, of about $10 million was required to get that up and running, or maybe it was one. I'm sorry, it's not my portfolio, so I'm not over those figures. But there will be operational issues or operational reasons why they needed to have that for firearms. And I guess all the work that we're doing here at the moment is part of that. But yes, so that's new one. Sorry, that 18 million wasn't something that I had asked for.
And just one quick stuff on that. What engagement has the minister had with rural communities and hunting clubs, etc., who use firearms for pest control, for food, for hunting, about the changes, whether or not they are around the fees that the minister's not responsible for, but the changes to the system?
Quite a lot. I'm on the road extensively. You'll see from my proactive diary reports the different clubs and ranges that I do go and visit. That's when I'm out and about talking to people about what we're doing, what's coming up, what the timeframes are. Constantly at clubs, and they're all different types of clubs. There's small bore, full bore, deer stalkers, rural, city, everywhere. Really enjoy doing those, having those conversations with them. Tend to try and go wherever I can, wherever I'm invited, to be able to get my message out about what's changing. It's really important because there has been confusion over the last few years about some of the changes, and then now, of course, another government's coming in and making more changes. So trying to get out there as much as I possibly can to talk to people about what's happening and what's going on. Some of the other interactions will be with my officials. We have quite a large number, extensive number of firearms groups that they are constantly working with, and they get feedback from them. One of the main ones that we talk with is the Firearms Community Advisory Forum, because that's made up of quite an extensive number of representatives from all different community associations and with community use as well. Rural Women New Zealand, for example, are on part of that group. So I feel that we do capture aspects of all of the firearms community with the different groups that we have that are spoken to not only by myself directly when I go out and about, but also by officials when they're canvassing ideas.
Good. Now we've got a supplementary from
just
Dr. Webb.
On fees and costs, you've been pretty keen on good licensing regulation. Do you agree that the costs of licensing should be fully paid by the gun owner, or do you think it should be subsidised in some way by other taxpayers?
Yeah, I think it should be subsidised, and I'll give you a bit of a reason why. You'll know under the previous Labor government, when they did their assessment on their fees and they looked at full cost recovery, and they were talking about over $1,000 for a licence for 10 years. That in itself is going to preclude people from being able to participate or even want to get licensed. The whole point of having a regime that's going to be effective with public safety is making sure that we keep people in the tent. If we start pushing them out of their tent, then we increase the grey market, which eventually increases the black market of guns. So it needs to be affordable. But it's also, if it's public safety, it's a public safety interest for this government to make sure that people are behaving and acting correctly.
Do you not think it's pretty extraordinary? Do you not think it's pretty
We're going to go to a new line of questioning from Ms. Anderson.
do you not think it's pretty extraordinary that ordinary New Zealanders have to pay for other people owning guns?
Well, they have been for this whole entire regime. And in order to make sure we maintain public safety, we need to make sure that people want to be compliant and be a part of it. Now, you may think that $1,000 is all right for you, but a rural member of the community may think, well, you know what, Mr. Webb, I can't afford that, but I still need to go put food on my table. Excuse me, I'm still speaking.
That's enough.
Still need to put food on my table. So I'm going to go do it. You asked the question, but you're not interested in the answer. Because it's not an answer that you want to listen to.
All right. Thank you very much. Now we're going to move on to a new topic.
Mr. Chair.
Ms. Anderson.
What is the expected timeline for the FSA transfer in 25-26, and what costs have been set aside for this?
The expected transfer will happen before the end of the term. We're looking to make sure that it does occur in 2026. The expected costs are still being ascertained.
What advice have you received from police or your officials about the cost of a potential transfer out of police? You must have received some advice on the broad aspect of what that cost will be.
Yes, I have received some advice, and the advice actually at the end of the day, I've received a couple of different sets of figures. And what's actually boiled down to is it's very hard to ascertain exactly what it's going to be. So we need more work. And the reason for this is because we're removing, police had everything. They had policy, they had regulation, they had administration, and they've had enforcement. Even when they created Firearms Safety Authority, there's been a bit of a blurred line between some of the regulatory and enforcement side. So the first thing we need to do is actually figure out what is being transferred in order for us to put a cost to it. Because if we were to say we were going to just lift and shift, that's actually not as easy as it sounds, because there's so many of the enforcement side of police work within it. So before we get the actual costs now, we need to decide what it is that these two agencies are going to be doing and then cost it.
Does the Ministry of Justice or even DIA have IT systems that are secure enough to host the Firearms Registry? And are we talking like thousands, millions, like ballpark?
And this is part of the exploratory work that we need to do in this space. Once we figure out who's keeping what information and how secure that information needs to be, then we'll know what IT systems need to be in place. So that will come as part of the costings that we're currently looking at.
Okay.
Or undertaking to see.
In terms of those changes that you're overseeing with the rewrite of the Arms Act, have your officials made a convincing case to you why shooters should be allowed to fire an assault rifle on a shooting range?
Yeah. That was not for the officials to make any cases for me on that. I'm the one that's been making the reasons for that. And it's also my idea to come up with I think the more stricter and harsher regulations around allowing that to occur. My officials were looking or giving me feedback saying that their recommendation was that we don't do it, but then that's their entitlement to say that.
Okay,
Can I ask one last question, please?
All right, last question.
What bona fide sporting codes in New Zealand use MSSAs in sports competition?
Pistol New Zealand and service rifle.
Okay. Now, Mr. Stevenson, I think you've got a new line of
questioning, and actually something I know that's dear to the chair.
And hopefully it's going to be an estimates.
It is to do with estimates. Obviously, again, back to this policy advice and things that you're responsible for, Minister. And I know the chair is very interested in this issue, and you talked about it at the start. This is really around AML and CTF reform. And obviously, there's going to be some more work that you and the Ministry will be doing going forward. So I'm very keen to understand, how are you trying to lower the regulatory burden for business and others in New Zealand around basically AML?
Thank you for the question. And I know that the chair does have a special interest in it. May I just start by actually thanking the chair. In your previous role, you actually taught me quite a bit. And I appreciate that as I'm starting to move through these changes. The AML CFT system. It's very complicated. It's really hard to get your head around. I'm very grateful for the officials that I have and the way that they've been able to help me understand some of the changes that we need to make to be able to get rid of some of the red tape. The reason why I'm saying all of this is because it's not easy to just make a change and know what difference it's going to make, or whether or not there's going to be a flow-on effect from those changes that you've made. So what we have looked at in the first instance is a work program, and this work program has got several stages in it. The first stage has already gone through, where we have produced a couple of bills that will look at introducing a single supervisor and also a levy to pay for it. What we had in the past was about 12 years ago, we signed up with the Financial Action Task Force, and we said that we were going to create relief for New Zealanders while trying to stop bad money coming in. We had 3 supervisors who then really struggled to get advice out to businesses because they were governed by their own acts. And so nothing happened, and restrictions became more and more on people because no one knew what to do. So they did the absolute maximum that they needed to do for customer due diligence. We're going to make changes with the single supervisor so that we can start getting advice out there early, so that the businesses will realise what they have to do and what they don't have to do. Further to that, we've also put in a bill where we're looking at changing the way that the trusts are having to do customer due diligence as well. There are 700,000 trusts out there, and 400,000 of them are low-level, low-risk trusts, and they have to jump through the hoops and confirm that they are doing the same sort of work that they have to jump through the hoops and confirm that who they are to the same standard as those other 300,000 high-risk trusts. So we're taking away some of the customer due diligence on those lower level trusts. I also have some other work that's coming. I can't speak about it just yet. But again, it's looking at making sure that we not only stick to our Financial Action Task Force requirements, because we have signed up to do that, but that we can give some relief to those trust members, to those mums and dads that want to open bank accounts for their kids, for the widows whose husbands have passed and they can't open a bank account either. We want to look at different ways to ensure that people can use digital identity as another example. And this will improve the way that businesses can operate, and then also with the way that individuals can work and go about their lives without having to do so much red tape and continuous repetitive red tape.
And so just one little follow-up, obviously, that's going to remove pain points for a lot of New Zealanders' everyday of life. Do you think it's also going to kind of help to contribute to the government's growth agenda and productivity agenda?
Oh, absolutely. It totally will do, because we're going to have less people trying to do, or, they're going to stop doing the mindless customer due diligence that they have to do when they know their customer and they know their person. They can just get on with growth, get on with growing the economy, making their businesses work, looking after their staff and looking after their customers, more importantly, as they come in. So this is going to be a big contributor. But not only that, not only do we get that benefit, but we get to go after the dirty money. We're following the money with AML, and we're targeting the real serious crime or criminal organised groups instead of every New Zealander who has a money card.
Thank you.
Very good. Now, Dr. Webb's got
it. So the Ministerial Advisory Group on Transnational Organised Crime sees this as one of our biggest vulnerabilities. And I guess my first overarching question is what's happening to the capacity within our agencies, because this is a cross-agency effort, because there are some reports that there's been a significant loss of highly skilled staff, particularly in the intelligence sector. So can you talk about the capacity within those agencies that work together to address and detect this kind of transnational organised crime, in particular respect of money laundering?
Okay, so again, transnational organised crime is under Minister Costello's group, but what I will speak to is, sorry, can you ask your question again, Mr. Webb?
Well, the real question was, it wasn't just, it was really about the capacity to detect and the loss in capacity to detect across the network of agencies that deal with organised crime and money laundering.
Okay, well, I can't talk to the organised crime part, but I will talk to the money laundering, although it's not part of estimates. But what I will say is we had 3 different supervisors. So I'm talking to the area that I'm responsible for: Financial Markets Authority, Reserve Bank of New Zealand, and Department of Internal Affairs. By having one single supervisor, Department of Internal Affairs, we have moved some from the Reserve Bank of New Zealand and Financial Markets Association into the DIA so that we don't lose the intel from those other 2 organisations, but that we have that one single supervisor that is giving out the information. So from my perspective and what I have control of, we haven't lost integral people, we've moved them over.
Okay. Well, my question was more about the enforcement end, but I'll ask another question because it's an important one. The other major vulnerability was around virtual assets or crypto.
Yeah.
And I'm just very interested to know what's being done to kind of close that loop. Obviously, it's difficult, but one pretty clear point is these crypto ATMs, which appear to be able to launder money in the broad light of day.
I have some work that will be coming out pretty shortly that will be able to answer your questions on that. That is something that I am aware of. It is something that I do want to focus on. But at the moment, I am progressing some work and I just need to get through those stages.
Okay, thank you. Oh, sorry, and
just for the member there, I guess some of your questions earlier about the kind of the stewardship of this anti-money laundering, and it's incredibly important because it underpins a whole lot of a prosperous, productive society, confidence, and it's the sort of the lifeblood of corruption and all of those things. What we have responsibility for in the ministry is essentially stewardship over the policy and regulatory side, and that's then that's the work we're doing with the ministry and actually with other ministers, of just supporting that picture. Underneath that, there's a whole lot about the operational end of it. We can influence that, like going to a single supervisor will absolutely enhance, I think, the capability and capacity of the system. There will be other parts of it though, obviously IRD and the agency, the intelligence agencies all have different pieces of the puzzle. We don't have any particular say in that. We do have something over the regulatory and policy system.
okay, we're going to go to a new line of questioning. We've got about 5 minutes left.
Thank you, Andrew. What advice have your officials provided you around the need for tougher laws for the illegal manufacture of 3D firearms?
Wow.
That will be difficult for me to answer, Mr. Chair, because we are in the middle of an Arms Act rewrite, which we have said that we do need to look at
That's the answer.
3D printing. So
That's the answer.
Okay. Are you considering tougher penalties introduced?
Now we're really skewing into, we're not even trying to get close to the estimates.
All right.
what I will confirm though,
last one,
it's an answer I'm willing to, it's a question I'm willing to answer, Mr. Chair, which is we are reviewing all the offences and penalties, every offence and penalty in the Arms Act, including if we look at introducing anything new, we would have to look to introduce new penalties or offences for that.
Okay, I think the last question.
One more.
Yep.
Are you aware that from 24 June of this year, you will have to register your firearms if you want to buy ammunition?
Yes.
Are you stockpiling ammunition to prevent registering your
come
firearms?
on. You're
That's
not asking a
ministerial
minister.
question.
Yeah. Right, Minister, I think we have come to a close. I want to thank you and the officials. I've got to acknowledge that we really didn't keep close to the estimates issue, but thank you for attending today and being open to asking some of those more wider ranging questions. But there was a gap because particularly in relation to the firearms, it wasn't covered before. So thank you everyone for attending.
Thank you, Mr. Chair. Thank you, members.
Thank you.
For good dinner tonight.
There's something.
Finish you later, we're going to go.
But the incentive, but wrap it up.
Oh. It was the only thing I just sort of like to get them.
Next time, we need to be proper.
Oh, no, did you get?
Where are the groups?
Only the ones that are worthy.
Right. Lindsay, I hope you're going to be able to write all that up in relation to the budget.
Yeah, so is it a strange one? I didn't realise you were bringing in that minister for this particular hearing because it's the budget's under
Anyway,
place
we'll,
now.
we'll do a debrief later. Okay, we'll get the Attorney General on. Everyone, we've got,
Push on.
yeah, we've got a couple of things. We've got, Attorney General and we've got, Parliamentary Council, and of course, she looks after both. What are you eating, Carl?
I've stolen some of his nuts.
Oh, you've stolen his nuts. We know you.
She is.
Hello.
How are you?
I'm very well. I thought we were over for some reason. I was willing it.
You've been going all afternoon?
Yeah.
Yes.
Still going.
Saving the best for last.
Some of us were here in this room in the morning.
Well, thank you for doing your service
That's
to the
all right.
country.
We've toned the language down the afternoon.
Okay, good. Where's Miss Anderson gone? She's disappeared. Anyway, we'll get started.
She's gone for a disposable take.
You're right there? Right.
Just being mother.
First of all, I'd just like to acknowledge and welcome the Minister and also the officials. This is number 5, I think, and 6, and we've got one after that. So we're having a long day of hearings, but appreciate we've got 30 minutes with you. Minister, as you are aware, sort of 3 minutes standing order requirement now that you just give us a brief introduction, then we'll go straight into questions.
Right, thank you very much. Thank you, Chair and Committee. And I'm very happy to be here today, accompanied by Una Jargos, who is the Solicitor General and Chief Executive of Crown Law on my left, and representatives from Crown Law are also here to assist with any questions if asked, if needed. So in New Zealand, the rule of law is respected and implemented fairly. It is what we are known for internationally, and upholding the rule of law remains of the highest priority to me as the Attorney General. It's also important to me that the law in New Zealand remains precise, clear, and not open to significant debate about its meaning, and that the government is able to achieve all its priorities, including all initiatives and reforms designed to increase efficiency and increase the value of the service and services we provide to the people of New Zealand. I'm joined in this mission by the Solicitor General and Crown Law, whose support for the discharge of the constitutional functions of the law officers of the Crown, leadership of the government legal network, oversight of public prosecutions, and provision of legal services are essential. So I'd like to thank all the staff at Crown Law for that. The year ahead, Crown Law serves New Zealand by supporting government to operate lawfully. Having that support enables us to implement our chosen policies and meet the expectations that New Zealanders have of their government. While Crown Law will continue to support all work as directed by the Cabinet directions for the conduct of Crown legal business, the Solicitor General and her leadership team have agreed that the focus areas for legal services will be digitising government, economic growth, law and order, and continuing to support the law officer functions. Addressing any ongoing financial sustainability remains an organisational priority. Crown Law are not required to make any savings as part of the Budget 2025 process, but I expect it will continue to be fiscally responsible and review expenditure on an ongoing basis to ensure it's delivering value for New Zealand. Approximately 2/3 of Crown Law's funding is used to support public prosecutions through the Crown Solicitor Network. And in conclusion, Crown Law will continue to focus on what is important and will do its utmost to maintain public trust and confidence in the rule of law. Many thanks to the efforts of Crown Law, the government is positioned to deliver what is asked and expected of it by New Zealanders in ways that enhance trust and confidence. Happy to take questions from the committee.
Thank you very much, Minister. Now we're going to start off with Ms. Walters.
Thank you, Mr. Chair. And firstly, just to thank the Attorney General and the Solicitor General and the Crown Law team for their time. I know we're short on time, but I did just want to acknowledge the exemplary performance of the entity, including I had the opportunity to go to the Women Lawyers event across the road not long ago, and there was reference to the Crown Law effect in terms of senior women appearing in senior courts, of which Crown Law is an exemplary example. So many thanks for your work. While there hasn't been a significant deduction, I believe the overall reduction is 0.23. What we do know is that Crown Law is facing more complex work and certainly an increase in demand, which we know, for example, through the patterns in 2023 to 2024, there's 25% up in terms of accused criminal appeals, 132% increase in terms of the Waitangi Claims Tribunal. New Crown prosecutions also up in terms of that period, and overall the hours of service provided by the Crown Solicitor is a significant portion up. I understand that part of that is to clear a backlog, but in the context of having to do more complex cases, the first question is how will that be managed? Looking at the budget lines specifically on defending appeals and public prosecution service, both of those look like they have faced a small reduction. So if you could please speak to those two lines specifically.
Having you do that detail?
Yes, off you go.
Thank you. There's always cost pressures rising, and as you have identified, projected increases in the work, particularly for our Crown solicitors who are funded in a bulk fund. So they do however much work there is for a set sum. And you've identified that it looks like there has been a decrease, and you're right, there has been. Some of it, though, has been a planned coming to the end of increases. For example, when the sexual violence changes were made, how sexual violent crimes are prosecuted, there was an increase in funding across the system. Some of it came to Crown solicitors. It was sort of front-end loaded, might not be the right technical term, but it was loaded at the front in order to make sure we got training and got used to changes in practice. And then we planned to tail that off. So we're seeing the first year of a tail off. So that's one place where there's been a sort of scheduled decrease, I suppose you might say. Within Crown Law itself, we have also decreased a small sum, I think it's only $100,000, that we did have funded for IT investment. We don't need that. We have removed that. So there's been, they're quite minor in the scheme of things, but those are the two that I can think of showing reductions.
Yeah. Thank you for that. Just as a supplementary, so the capacity to respond in terms of prosecuting those sexual violence, sexual assault cases remains as is?
Do you mean we haven't taken any capacity out of the system?
Was the capacity attached solely to training and education, or was there some capacity that was delivery of the prosecution service?
No, we haven't taken capacity out to deliver.
And the other question I'd have is...
Just to be clear, you haven't taken capacity.
We have not.
Yeah, no. Can you just bring that, just so people will be recording this. Yeah, sorry, Vanessa.
In terms of forecasting into future years, I'm very aware that we have the launch of the TICA program in August or September this year, which will be a new tool aimed to increase sexual violence reporting. Are there some efforts to look at forecasting on the basis of potential increases in that area?
Well, we are part of the justice sector that does throughout the year. And in fact, they've just released their forecasts for the next period ahead, which does show that serious violent crime, which will include sexual crime, is forecast to increase. So we do watch those forecasts, of course, and work with our Crown solicitors to manage that. We do see that within the next couple of years, we can balance our budget. In year 3, we think those cost pressures start to look quite hard to manage. So we'll be watching them very closely. If that projected increase occurs and nothing else changes, then we will start to worry about Crown solicitors' capability, sustainability.
Thank you.
No more?
Well, I can keep going.
Yeah, you keep going. No, I'd like you to keep a line of questioning and then we'll move to something else.
Well, this is on a different line of...
You got anyone else want to jump in, right? Mr.
Thanks,
Bates.
Chair. Just in relation to the questions around decreases and increases in the appropriation, can you just speak for a minute about the increase in the appropriation related to remuneration and support of your team?
Sorry, could you just, what are
So
you
my-
referring to there in particular?
So my understanding is there's a specific increase in the appropriation around remuneration pressures.
No,
There,
Sophie. Yeah, we allow for it, sorry. Oh, from budget 2022, do you mean?
oh, we're still carrying forward, yeah, that's
Yeah.
true. There was an increase in the appropriation in budget 22 to accommodate remuneration changes.
And
And,
that's
again,
current-
and some
and
of it has
that's
been
continued
carried forward.
currently.
Yeah,
Yep.
beg your pardon, misunderstood your question.
If you're going right, we'll go back to you.
Just
Yeah.
a supplementary on that, looking at the responses to questions, it looks like there hasn't been a great shift in terms of people moving up those remuneration bands. Have you noticed, to stay within budget, that there's been a need to keep those bands and the corresponding numbers of people within those said bands more or less the same?
We do have a process in play where people move in the bands, but we keep very close eye on how big the band is. We don't move that lightly. We must maintain our capacity within our baseline, and that's one of the easiest ways to do it is keeping an eye on remuneration. It's our biggest, our people are our biggest asset.
And may I just finish this off, and then we're going to go to a new line. So the capability, the issue about pay and one is capacity. The other side of that, of course, is capability. Could you make some observations around that in terms of the excellent work that your office does? But obviously, there's a lot of pressure in the market generally. How are you coping with that?
Well, it's not entirely straightforward, but we do keep our eye on making sure we are keeping our people occupied, trained. We have no shortage of interesting work that builds the capability both within our own office, but also outside in the profession when we need to reach out to the profession. So there's no shortage of development opportunities. We continue to be a really interesting, great place that people want to work. So while we know that people will say remuneration is something that is a bugbear, we are able to retain very talented people.
Right. Any other questions on that line? Okay. We're now going to get back to Ms. Walters about a new line.
A related topic, but a new line. In terms of the Crown Solicitor's fees and the dramatic increase, would you be able to speak to that and whether it is related to addressing the COVID backlogs or whether that's a different project? They look like two different pieces in the budget where the COVID line has ceased, but that additional funding has remained, or
Sophie, do you want to answer that?
Yeah, again, do you mean the funding from 2022?
Yes.
Yeah. The bulk fund hadn't been adjusted for inflation or for any of the increased complexity of cases, the concurrent then or the commensurate increase in hours that are required. Bulk fund hadn't been increased. In 2022, it was increased to be in line with departmental rates that agencies would be charging, that private legal firms, law firms would be charging departments. So it was increased, brought up to that baseline. That baseline will remain. As Una said, we think that we can maintain current standards and current capacity for the next couple of years. In year 3, though, we will see the increase in volume start to surpass the amount of funding. And it's at that point that we'll be increasingly concerned about sustainability of the network.
And is planning for sustainability, should there be an inability to move that ceiling, already happening?
Yes, and that our public prosecutions unit keeps a very close eye on that and how the fund is dispersed, and how we can do that to maintain that prosecution function.
Can I supplement?
Yeah, of course.
So Crown Law itself only conducts appellate criminal cases, if I've got that right. And yet it does so very effectively and efficiently. Has there been any consideration given to Crown Law doing trial? Because you appear to be a more effective, cost-effective deliverer of legal services than Crown Solicitors.
Oh, I'm not sure that I'd agree with that last proposition. Because Crown solicitors do a very good work for the Crown on rates that are kept very below competitive. They're kept very
Almost as low as legal aid lawyers, but not quite.
So, but we haven't done any particular study recently about whether Crown Law our office should do the trials.
Yeah, I guess it's a suggestion of whether there's been any thinking around budget efficiencies move towards a public prosecution model rather than a Crown Law model.
Well, there's none from me and there won't be while I'm the Attorney General, but no doubt one day in the very long future, somebody else might change it. Well, we need to have officers in all parts of the country that currently the Crown Solicitors or the network deals with, and that's one of the issues. The other issue is that Crown Law is seen as a place where there's a lot of work that's not only criminal, that there's a lot of very interesting treaty work, very interesting work around employment, all sorts of things, public law. And I think that's really where we get our biggest bang for the buck, actually.
Right, Vanessa, you're back.
Thank you. There's a little bit of discussion within the documents about the unpredictability of the caseload, if you like, and working out how to manage that risk in terms of the cases that are brought against the Crown. I noted that there was an increase in the number of judicial reviews, for example, in the last cycle quite significantly. There's an interesting interrelationship with the role of the AG and Crown Law in terms of managing risk through the production of legal advice, but also Bill of Rights Act vets. Prior to legislation being finalised that opens the government up to risk. So I understand, and this is a forward-looking question, but just for context, I understand, Madam Attorney General, that you received advice on the 15th of May from the Ministry of Justice in relation to the Regulatory Standards Bill.
Okay, let's bring it back to the estimates.
It is forward-looking because the advice concluded that, one, they hadn't received the final bill yet, and then quite surprisingly that the principals did not prima facie breach the Bill of Rights Act, and that the bill as a whole.
Well, you still haven't brought it back to the estimates, but let's see if we can get there.
That wasn't the final advice. So there remains, in my view, a role for the Attorney General and potentially Crown Law in continuing to assess that bill. And so my question is, can the Attorney General outline how her office is assessing the forward-looking constitutional and fiscal implications of the bill's proposed elevation of property rights now, and if changes are made.
Let's see what the Attorney General's got to say.
Let's put it this way. If you're asking for what legal advice I give to the government, the answer is no, I don't give legal advice to you that I might be giving to the government, because it is really protected by the sanctity of the relationship as the lawyer for the government.
Very good.
All right, I'm going to go to a new line of questioning from Mr. Rutherford.
Yeah, and you'll get this question in about 10 seconds, and it's, does Crown Law intend to use AI in the coming year? And if so, how?
Yes. Who wants to answer that one? Oh, yes.
You can, we can.
No, you do
Yeah,
it. You do it. You do it.
We have been taking a cautious approach to our sort of case use of AI, like as of course, as everybody, but certainly everyone in the public service. We have just almost completed a process in which we are sort of pivoting our IT platform to something more modern facing and transformative. We anticipate continuing to use AI. We've used it in small parts and tests and sort of controlled use cases, but we anticipate being able to use that really quite soon for most likely sort of the productivity gains that can be obviously and easily obtained. We have a huge amount of material that's confidential, that's legally privileged, that's personal about people and litigants, that we will be very careful to build whatever system we need if we're going to use AI in that respect. Might not be in the next year. That really quite closed shop of how can we use it with our own material without worrying about privilege and confidentiality.
Aside from AI, are there any other technologies that are being used?
Yes.
Microsoft Word.
Yeah.
Okay, boomer.
Could you expand on the question? Are you thinking of particular technologies?
I'm
We use
thinking
standard
about,
Office
obviously AI is a big step
productivity
forward for us in 2025 and years ahead, but also other platforms that may be similar to it that aren't specifically AI operated that Crown Law could potentially be using.
We are at present, all of our use cases are around most of the Microsoft productivity suite. And so if you're thinking in terms of AI, are you thinking that sort of the difference between generative AI and other technologies? Yeah. We are at early stages of both of those. Okay. We haven't developed anything in-house. We wouldn't look to do that, certainly not in the next year. Right now, it's about finding instances in which we could use AI-assisted technologies to help us with mainly in our corporate functions and smoothing some of the processes and quite highly manual tasks, repetitive tasks like that.
Can I just make a comment to that too, to Mr. Rutherford's question? Even though I'm using a pencil here, we are also, we are very much using tech in our work. We've got 2 AVL courtrooms in our building that our people are constantly at court in our own offices. All of us can pick up our laptops and go into a room that can Zoom or Teams, take it, we take our whole sort of work computer, so we are technically ahead that way. We very much use tech in everything we do. But the generative question that I think that you might be getting at is perhaps...
And of course, we have to be very careful with that information. So we have a little small language model, not a large one.
Yeah, and I was going to invite the Minister to respond as well, because I know this is something close to her heart and a passion of hers as well. So, Minister.
Yes, thank you. And it is really important. So I think the point is too with Crown Law, which is a relatively small agency compared to many, that they're taking steps that they can with in building their confidence as well as their competence, and in their inquiring as to how else they can do things. But this is going to be very helpful in terms of actually freeing the lawyers up to be able to think about the solutions rather than to have to do some of the other things they're doing. So taking what I would call often some of the grunt work out of things. But we all know that the dangers of just relying on AI to come up with solutions on things. It is important that we have the human input as well. And I think that looking at the Crown Law mix of the people that we've got there's a lot of uptake of this. So they're really keen to be using the technology better and more productively.
Okay, a couple more on AI, and then we're going to go to a new line. Reem?
Yeah. So not necessarily AI, but within the milieu of digital components. In your introductory remarks, Minister, you were saying that the year ahead, the main priorities, there's law and order, restoring law and order, economic growth, supporting the law office functions, and also, I think I heard correctly, digitization. And so there's 1.08 million allocated additional appropriation for capital expenditure. Now, does that include the things as basic as we're just renewing not just, but we're renewing a lot of the hardware, but does it also involve what you said, Madame, that modernization of the platform that you guys use, your team uses, etc. Because, for the 1.08 million.
Yeah, so that is specifically CapEx, and so that is exactly as you say, that's for the hardware that we're using. Any of the AI, what we're trying to do with our digitizing, modernising our digital platforms is to move to software as a service, which is all OpEx. So although you don't see that in that 0.8 mil, because that's the CapEx investment, our focus is going to be moving from bricks and mortar on-premise software into more true SaaS, software as a service.
And supplementary, and you, I'm presuming this will improve service delivery. You can clearly see how that will improve service delivery as well.
Oh, absolutely. Yeah. And in many instances, like the rest of the public service, there is no choice you know, these technologies are no longer offered on premise. In order to
Right.
continue to use them.
Excellent.
Thank
Thank
you.
So we're excited. We're going to a new topic. Mr. Sunan.
Thank you, Chair. I have a question in terms of, I guess, a combination in terms of the workforce reduction that we see in the estimates in conjunction with borrower reports.
The workforce reduction?
The workforce reduction.
Where?
For example, page 14 of Vote Attorney General.
Most borrower reports are actually undertaken by the Ministry of Justice, not Crown Law.
But in terms of but then they're on behalf of the Attorney General in terms of borrower.
No, but it's done by the Ministry of Justice, mostly. There's the occasional one where Crown Law will, when it's a Ministry of Justice bill, but for most of the borrower reports I get, they come through from the Ministry of Justice to me, and then I read them, and then I make the decision. So it doesn't hurt them at all.
Okay. May I, in that case, ask you as the Attorney General about borrower reports? Thank you, Minister, for that clarification. One of the things we have been seeing, and this is a conversation I think we had previously, is that borrower reports are often coming late and not being uploaded on the Ministry of Justice, Ministry of Justice website promptly. And this is something that we are seeing a fair bit, but also in terms of the level of analysis that we're seeing that some of the sections of borrower are not being covered. I guess that's my first question is, what, in your opinion, within the estimates and within your role as the Attorney General, what are some of the measures that could be seen to improve the availability of the borrower reports on the website? It's my first question, but I do have a follow-up from that.
Yeah, sure. Just start with that. So number one, as I said, I'm not the Minister of Justice. I sign having read and accepted, in most cases, vast majority of cases, the reports, recommendations, the Ministry of Justice. I also sign an instruction that they be loaded to the Ministry of Justice website. I can't physically put them on myself. So that goes back through to the Ministry of Justice. So again, the Ministry of Justice needs to be asked, or the Minister, about that. But I am dealing with those every week. So I do my weekend bag, guess what, every single weekend. That's my weekend.
And this very much appreciate the role of the Attorney General.
I can't actually,
on
but
that.
I think you should take that issue up with the Ministry of Justice.
But in terms of just a supplementary, and your own response might also be taken out with the Ministry of Justice. But I want to check with you in terms of, do you then get access to or get advice from the Ministry of Justice when a substantial piece of amendment that may potentially have broader implications is being brought to the House during, let's say, during committee stage? Because it's
We normally do
This is really outside the
again, it's the ministry, not the Minister of Justice.
Right.
And it would depend on whether or not they chose to send it through.
Okay, a bit of latitude there. Last question. Try and get it into the estimates.
So to Madam Attorney General, I believe.
Oh, by the way, I should have said, welcome back.
Thank you. Part of the role, of course, is, in my view, that oversight in terms of the constitutional piece of ensuring that there's a balance between the judiciary, what's happening in the House, and decisions that are made in the legislature. I think we've seen a significant shift that looks minor in the budget lines, which reduces the size of decision makers in the Human Rights Review Tribunal from 6 to 2. And that's a unique tribunal because this is the non-renewal of the Deputy Chair's warrants. And it's significant in the context of your role, Madam Attorney General, because it is one of the few courts that has the power to issue declarations of inconsistency. And I wonder whether there's an opportunity in the coming period, given that this is a new decision that's been taken, for you to advise colleagues about that constitutional balance and ensuring that we continue in New Zealand to protect the right of people to bring a discrimination claim at the tribunal.
Well, thank you for that advice. I think it's important that I continue to give my colleagues advice on matters, and I do, but I can't tell you what advice I give them. but I can tell you I do give advice, possibly more than some want.
Right, I think on that fine note, we're going to finish. Thank you officials for turning up. Obviously, the minister's staying on.
Yes.
And we've got
Lucky.
PCO to join us, but thank you everyone for participating in that.
Team, Crown Law. Take the gift to Crown Law.
Yeah.
The water is free.
Thank you for PCO as well.
I think I've lost my piece.
But hopefully we can stick to the estimates.
Oh no, here it is.
There we go.
Well, Cassie, how are you?
To be honest,
I'm pretty sure I have money.
I was under the guise of with the Attorney General, I could be asking Attorney General questions.
No, it's different. The Attorney General in the States is quite different from
Right.
I think in other places. So it just depends on which country. No.
So I just welcome all the officials. Thank you for enduring that last one as well. So Minister obviously knows what she's doing, and then we'll get into
So I just-
questions. Who's the-
Okay, right. So I'll start off.
Yes,
Thank you
please.
very much. And I'm accompanied by our Chief Parliamentary Counsel, Cassie Nicholson, and representatives on the Parliamentary Counsel Office, and also who are here to help assist with any questions. New Zealand is at its best when trust and confidence in government is strong. The PCO plays a critical role in maintaining this trust and confidence through the drafting and publication of high-quality legislation. And the legislative program delivered by the Parliamentary Counsel Office is essential work to support the government to achieve its priorities for New Zealand. PCO's greatest asset is their people. It's a great asset, by the way, who are committed to delivering strong outcomes for New Zealanders. And I would like to personally thank the staff of the PCO for their work. PCO supports a stable, prosperous and well-functioning democracy for New Zealanders, does so through its law drafting and publication role, and also more broadly by taking a leadership role for legislative quality and access, promoting high-quality legislation, easy to find, use and understand. Over the coming year, PCO will continue to focus on delivering a significant legislative program for the government. Delivering meaningful and effective legislation requires resources. It can be complex. It requires coordination across the entire legislative system, and the consequences of getting it wrong are severe. So I will continue to support Parliamentary Counsel Office and the Leader of the House to drive effective prioritisation of the government's legislation program. We will use good lawmaking processes consistent with the rule of law and constitutional principles. We also need to support PCO in improving its resources and tools to ensure we maximise value for the public. My other key priority for PCO in the 25-26 year is to see us establish a single point of online access to all legislation. And I know that Ms. Walters will, from our time with the Regs Review Committee last year, will know how excited I am about that. Not last year, before. So exciting. PCO has therefore developed a decentralised publication system to make secondary legislation searchable from the New Zealand legislation website. Thank you so much.
Yes.
Agencies will continue to publish secondary legislation on the websites, and a technology solution to identify and link to that secondary legislation on the New Zealand legislation website to create a single point of online access. This will, over time, turn the website into a one-stop shop for all legislation matters. This is something I have championed for many years, with the aim of the public having to visit only one website to find all New Zealand legislation related information. This is a productivity gain, but enormously helpful in access to justice and the rule of law. Improving access to and quality of legislation promotes people's understanding of both their legal rights and obligations, increases certainty and lowers compliance costs. It's vital that we do this. As well as the benefits gained through improved access and quality, this work will contribute to digitisation of government, another area which I am excited about. And while the PCO has not been required to make any savings as part of the Budget 25 process, I expect the PCO, along with other agencies, to exercise fiscal restraint and to keep reviewing its spending to see how efficient and productive they are. So well-designed and accessible legislation is essential for a well-functioning democracy. Thanks to the work of the PCO, we can continue to build on that strong democracy. I should also have mentioned the work that the PCO does particularly in the Pacific with our Pacific neighbours, around helping to bring their legislation helping them with it, but also with training and everything else. And PCO does a great job, not only for New Zealand, but for the wider Pacific community of which we are part. So thank you very much. Happy to take questions.
Thank you very much. I just want to reinforce those words from the Minister about the good work of PCO. We're going to start off with Ms. Walters.
Thank you, Mr. Chair, and the Minister and PCO colleagues for the extraordinary work you do over everything, really. I'm equally as excited about the Access to Regulation project, which I'm sure we'll speak about. But I did want to start just by, again, acknowledging the breadth of work, but also the commentary on its increasing complexity and the increasing stress or pressures that the team are on. And wondered if you could start by perhaps generally commenting on that, and maybe also commenting on the impacts of urgency in terms of being able to manage the workload.
Do you want me to talk on that? Do you want to talk on that? Or do you want to talk on that?
I can.
Off you go.
I can speak to that.
Yep.
As you know, I mean, the PCO is a demand-driven organisation and always has been. Our job is to support the government of the day to deliver its legislative priorities. And as you point out, it's certainly true that the trend is for legislation to keep increasing and getting more complex and larger. That is a worldwide trend. It's not specific to New Zealand, so we're not the only jurisdiction to encounter it. I really do think we're doing a great job at delivering to those needs. And, you know, I guess really core to that is working closely with the Leader of the House, being really clear that we're delivering to the big government's priorities of the day. But alongside that, obviously, we need to be very agile as a workforce, need to rely on our really excellent people that we have, need to make sure that they're pivoting quickly to what that needs to be done, and that they're working really well together as a team, both internally and externally with our partners. So it's always a challenge to deliver those priorities, and the middle year of a term is particularly challenging, probably. And I think we'll always have we have a series of initiatives in place that are going to continue to improve our resilience.
Do you want to talk about use of AI?
I can talk about it.
That'll save the question from Mr. Rowe. Will it?
Well, it's just something that helps with
no, of course.
Perhaps you want to talk a little bit about that?
I certainly can speak to that if the committee would.
Yes, certainly. Yes, we would welcome it.
I mean,
feel free,
gladly.
One of our key initiatives is really to use digital tools, including AI, in improving our efficiency and effectiveness of working, particularly efficiency, but also improving the quality checks that we do to ensure our work stays robust and is effective. So we've been doing some early work in research and development into AI tools. There's about 5 use cases that we've advanced. We've been cautious about how we use it. Obviously, and these are early prototype tools that we're building, so still some way from production, but we are seeing some really exciting results. There's perhaps I can pick 3 to tell you about in the first instance, but we're looking at a use case around creating explanatory notes automated for the first version of the explanatory notes for legislation that we can then check. So again, just speeding up what otherwise people would manually have to produce at quite a repetitive task. We're also looking at producing a Principal Act consolidated in with the amendment, so that select committees can actually see amendments in the context of the principle, which you can see would really add a lot of quality input for both the committee, but also to officials and to the public working with legislation. And the third one that I've highlighted to you is, I guess, we're looking at how to more easily review draft legislation against plain language and other standard requirements. So one's about efficiency, one's about kind of improving our quality resilience, and the other one's really about enabling better access to legislation.
I'll go to Mr. Bates on the specific issue around AI, and then I'm back to you.
Thanks, Chair. Just interested in the wording you used around building and whether or not you're building this stuff from scratch or you're using off the shelf internationally in some form and adapting.
Where I might call on my colleague, Andy, for a second, but we are partnering with a series of people. But yeah.
So
Oh, don't sit down.
have a chair here. Get a chair. Come on, not having been on your knees. Thank you. There we go.
So, can you just introduce yourself, please?
Yes,
So
Andy
the
Neal.
AI can record who you are.
So Andy Neal, DCE for Access and Digital Services.
Right.
As mentioned, it's early days, research and development, and we've taken an approach at this stage of looking at what open technologies we might use. So particularly looking at the open source space.
Yeah.
And the basis for that is we think we may need to be able to control our technology stack, if you like. We know that there are a lot of off-the-shelf products, but there are also thousands of models out there that could prove to be very cost-effective options. And so at this very early stage, we are kind of casting our net quite wide. We're certainly not against taking off-the-shelf products, but this is a very new and emerging field. I would also just clarify, we're not building anything ourselves. We're working with local experts and utilising the incredible talent we have in New Zealand to give us the advice, which, we're not experts in this space, we're learning. Yeah.
Okay, do you want to carry on with the AI, or you've got an AI?
No, I got a new question.
Oh, no, you carry on.
Mine,
All right.
yeah. Although I enjoyed that
Thank you,
diversion
Andy.
because I think the AI.
I don't think we've finished it, have we? We'll come back.
The AI horizon is very exciting. But I think just in terms of managing the horizon for the next year and a half ahead, on the urgency issue, I am really curious to know how there's risk management planned around that. And whether we've had commentators talk about this extraordinary use of urgency
And how it relates.
and looking at the figures on temporary contracts, there are some consultancies in there. So the question is a proportion of this outsourced to consultants, and to what extent are things outsourced to other departments where the work would otherwise be done and preferably be done by PCO, but for the fact that urgency is hitting at pace.
Well, there's a big assumption under all that, but let's have your response.
So I guess a couple of points. I mean, urgency, as you say, is a tool used by successive governments to try and improve the amount that they can achieve in a parliamentary term. In terms of our risk management strategies around us, we work for that. We work very closely with the Leader of the House to try and give good advice about what's ready for urgency. We use our drafters to ensure that we're scoping things well for that, and we make sure that there are any risks of using urgency for particular legislation is very clear. Looking more broadly, you were asking, sorry.
And in terms of the proportion of what you use contractors to manage in terms of capacity versus it being.
How do you use them
with
flex,
both
I think?
departments?
Sorry, we do use ex-drafters who are on a legislative services panel to enable a bit of peak capacity to go up. So that is a portion of our contractors and spend. It is not a huge proportion, however, and we don't outsource to other departments. So we are managing to keep up at this point, but it is, there is a lot of work.
Do you have a view on the number of pieces of legislation that have been passed in the last year vis-a-vis comparative years going back several years? Is it because there's an assumption around urgency and that leads to even more workflow? It also comes back to the abilities of ministers to actually generate activities. Have you got a view on that?
The legislation program has been growing over the last 15 years.
Yeah.
It does grow year on year. The capacity of what goes through Parliament hasn't grown quite as much as the ambition has grown. So there is a natural limiter in terms of how much Parliament can achieve. And so we, as Cassie was saying, is we work quite very closely with the Leader of the House and with ministers to make sure that that the ambitions of ministers and of the government is able to fit with the capacity of the system to deliver.
Cool. Any more? Right. Lawrence, did you have one?
Yes, I have a new question.
Cool.
And it's tied into the appropriation around drafting access to legislation. But first of all, I just want to say that we had an early access sort of tour of the new legislation website in Regulations Review Committee. And this was surprised no one, but it was exhilarating.
Great.
It was great. I loved it. I could not stop smiling, particularly the part where it talks about, bringing in secondary legislation. But onto the actual estimates. So we've noticed that in terms of the total appropriation for drafting access to legislation has decreased, but that's factoring into the fact that there is, in a supplementary budget, that there was an additional 413,000 that was given, or that was added on as part of 2024-2025. So the baseline funding hasn't actually increased. But what we are hearing is that with the launch of the new legislation website and everything attached to it, that there will be more demand, at least initially, for work done by PCO. So I want to check with you is if we're looking at either the 413 was a one-off, or we're looking at a decrease potentially in terms of budget or staying the same. What is from PCO perspective, how are you able to continue working on that really amazing piece of work with the same resources? Or has that already been factored into a baseline?
There's a couple of things. In budget 23, we did get an increase, a portion of which we used for our most critical workforce needs, but we've also used some of that to go towards delivering the access to secondary legislation project within baseline. On top of that, we were not required to make any savings in either budget 24 or 25, which has enabled us to get to that point where we could deliver that project. A critical part of our plan, though, has been to go to a decentralised model, which is not as expensive as what was originally conceived of, using open source technology that is available already, and that has made it easier to deliver a lean delivery model. In terms of that 400, right. So we did have time-limited funding to do a business transformation program to basically shift our system to the cloud, and that finished. But there was a carryover of that 400 into the next year. So that's it.
Basically, what we're seeing in terms of the budget document, that it wasn't so much a reduction on, but it was a carry on and staying the same. Okay.
Yeah. Right, Ms. Walters?
Just a supplementary in terms of the change of the way in which the project's being rolled out, which is different from when I was last in, and I think explained it as more that coordinating role that PCO would play. Is there a risk assessment of that, and does the open source create any risks around what would have been a more coordinated
This is
model?
public information, isn't it? Already available. So.
Yeah, the open source software I'm mentioning is like an aggregator tool. It is a tool that basically grabs the links. Again, Andy, you feel free to jump in and explain.
Yeah, perhaps we'll get Andy.
I guess my question is really around that it would still rely on the departments proactively fulfilling their obligations. And I think from memory, and it was a few years back, the big shift is that statement that once published, secondary legislation is law across the board in that unified system. And so if there's a shift in terms of the responsibility, is there some active training or coordination or some oversight governance mechanism that will ensure risk management?
I'll mention one thing and then I might pass to Carl.
There's actually not a shift of responsibility. Ministries still have to put their information on under the law. But I know that the Public Service Minister, with whom I am closely connected, is very serious about this too, as is the Public Service Commissioner. That's part of their jobs, to make sure that this is happening.
But yeah, and that's right. And so that emphasis on agencies actually stepping up and doing their publication is essential to the success of the tool. but we aren't relying just on goodwill there. We are doing a lot to support them, but we do have a legislation amendment bill in the House now. Did you want to talk to that?
Yeah, so
Yeah,
so it's multi-pronged. So there's a legislation amendment bill in the House at the moment. It's waiting for its first reading, but that will set legal requirements for agencies to publish in the way that will enable our tool to pick it up. So it's a legal requirement that they do that. We've also issued, with the support of the attorney and the Regulations Review Committee, access standards that's really set the standard for agencies. We've set up drafting. We're doing drafting training for agencies. We've got access specifications for them to use. We've also started a community of practice really to get those agencies on board, and we're working really closely with them to make sure that both we understand the situation that they're in, but also they understand the shift that they will need to make in order to comply with the new legal requirements that will apply to them from about the middle of next year.
Lawrence, here we go.
Thank you. And this might be a question for Andy, because I'm about to ask about the aggregating tool that is used to pull in secondary legislation. I think with the previous conversation we did have about this, there was some questions around the ability to pull in older secondary, because like what you said, there's going to be a new piece of legislation which have those kind of requirements. It's easier for the aggregating tool to actually pull them in. But then we will get to a stage where people will rely on the legislation website to have 100% accuracy in terms of secondary legislation and being able to link those secondary legislation from the primary. But at the same time, you get the aggregating tool who may not be able to pick up on some of the older secondary legislations as a result of that. I wondered if there's been any further development in terms of the ability to pull in some of these older legislation, or going to be continuously operating under a disclaimer that says, please note that older secondary legislation may not be pulled into this or may not be in the system.
I could probably cover that from initially, and then maybe Andy might take over. So there'll be a transition period. Anything in force at that date will need to comply with the new requirements. So if you're talking about older legislation that's still in force, that will be brought into the new regime. For older legislation that was repealed, is revoked now and isn't in force, we are not requiring agencies to bring those out of the bottom of the drawer and then republish them. So it'll be a complete set of legislation in force from commencement. And then, so it will apply to all existing and all new. So all the stock and the flow.
But then there are older existing secondary legislation from various departments, and they are kind of on various platforms and etc. And how do you ensure that some of these older ones, because last time we couldn't get assurance for that, but some of these older ones will be able to.
So that's the law change.
So that's the law change.
So that says they have to put them there, otherwise they're not going to be operational. So the law is requiring them to do it.
That's right. And there will be an ability to make those automatically revoked if they're not republished. Now
it's a great incentive to get it done.
Yes, but we also have to be careful because businesses rely on the existence of those laws in order to operate. And so we have to be quite careful, but it's a balancing act. We need to improve access to legislation, but we also need to retain certainty for users as well. So we're trying.
So I think they've got about a year, we think, isn't it?
There's a year.
So the framework to get it sorted. So there's no excuses.
I've just got to congratulate. When I first joined 2014 as an MP, I spent 3 years on Regs Review, and we were project managing this project every month. And so it all just died, and I don't know why, but I've just got to congratulate you. And I say that in the royal we, you, in terms of bringing this to life, because it's so important for people. So congratulations. Can I just ask some more mundane things? How much is it going to cost? Is it substantial or not? Or is that cost largely been incurred?
It's within our baseline, but agencies will have to make changes to their systems, and we expect that they'll do that within baselines.
It wouldn't be much.
No, it doesn't sound like much.
I'm assuming it falls under the Attorney General, Legislation Design and Advisory Committee, which the Parliamentary Council has a part in. Is there anything going on there? Because there's another agency who's keen to give advice on legislation design and quality. And I'm just wondering how that's going to work out.
Oh, you mean the regulatory
Yeah.
process? Well, I'll pass that to you, Madam.
The bill's obviously at select committee, and so it's not, it's not yet clear what the final picture will be until it comes out of select committee. But I guess there's a couple of key points. Firstly, that there's obviously an overlap between the Attorney General's responsibility for the rule of law and the Minister for Regulation's responsibility in terms of under the Regulatory Standards Bill. That's given effect to, if you like, by the fact that they will jointly issue guidance under that bill.
Yeah, I saw that, yes.
Yeah. But in terms of the roles of the LDAC in the board, I'd say they are quite distinct. And that's, that I guess is evident from the fact that the bill does not impact on, it doesn't directly impact on the role of LDAC. So the LDAC's role really says, given policy, whatever it is, it's policy neutral. What is the way in which we need to design this to best meet good legislative design, take account of constitutional issues and things? And we're working closely with agencies in the development of the legislation up to introduction. I'd expect that the Regulatory Standards Board, will have a much stronger policy focus on the fundamental policy choices that are being made. And it's really there to hold, I guess, the executive to account to Parliament. So quite a different function from LDAC's function, I think.
Yeah. Can we just you wouldn't right
Stuff
on that? Okay.
But is there a proposal that there's a new consistency accountability statement against the principles of the Regulatory Standards Bill that PCO would have responsibility for drafting as well?
We'll have responsibility for drafting the bill, but not for the consistency statement.
No, the consistency statement is for the department.
Yeah.
Right.
Can we we're just about the end of time, but you mentioned the Pacific and the important work you do there. Could you just perhaps elucidate in terms of, is that a contractual arrangement or is that part of our foreign affairs work in the Pacific and the extent of the work that you do?
Well, we're very lucky to have had a long-standing arrangement under an MOU with MFAT. I think it started back in 2011, where they fund us to support the Pacific with effectively one full-time senior drafter, together with associated kind of assistants around that. Our focus is as I guess first and foremost with the realm countries, but we do give assistance to other Pacific nations through that, and it's a mixture of both drafting support and capability uplift. So we gave a couple of online training sessions for a mix of drafters earlier this year. We're part of a Pelon drafting conference in September, so we are connected in both through the Pacific desk and through our relationship with Pelon.
Good. Anyone else got any more questions? Right, we're finishing slightly early, just before 6. I want to thank the Minister for 2 attendances, but also the officials.
Yes.
Thank you for what you do. Bring home that project.
I know.
Imagine the AI you'll be able to run over the secondary legislation.
Exactly.
I mean,
Yeah, you will. Good point.
it'll be amazing.
Yeah, that will be amazing.
Yes, just one little thing. I've been reminded that we need to have you to sign up the demo website.
Yes.
Oh,
So some of
definitely.
you have already.
Come back to the committee.
Just
Come to
like,
the-
it's live now. so
It's
you can
live
sign up.
now.
You should come and give us a decent briefing in the committee.
Yeah.
We'll do.
We might invite you.
Well, we love to talk about the excellent work of PCO. Thank you.
Thank you for your help.
Great job. I mean, we see a lot of it.
Right, we just got a couple